Good morning. Sorry, good afternoon. Good afternoon. Just let me know now, is it visible and audible? Okay. Now let me know. Good afternoon. Good afternoon. Good afternoon, all of you. Good afternoon. Thank you so much, Kaushik, for such kind words. Good afternoon. And now, please tell me. I hope the voice and everything is fine now. Yes, the voice and everything is fine. Yes. So, I'm not going into again the pre-dialogues that I did previously. I'll just hope that you all have studied very well and you have come today for the revision class after having studied everything very well, so that this is just, like an icing on the cake for you all. So, as I told, obviously it's a revision session, so we cannot do everything in details. I'm going to go at a particular pace, okay? Everything will be covered. I'm going to go at a particular pace. But if at any given point of time you feel that you need me to explain something in more details, you can tell me, ma'am, please explain this topic once more, or please a little more in details, and I'll do that, okay? Same here, Akshata. So happy to see you all. So, Indian Contract Act 1872. The word 1872 here signifies what? This is the year the act came into force. It came into force on the 1st of September 1872 and applies to the whole of India. It applies to the whole of India. Now, obviously, the name of the act is only Indian Contract Act, right? The name of the act is Indian Contract Act. So, obviously, the act is something to deal with contract, right? The act is something to deal with contract. So, what exactly do we mean by a contract? What is a contract? The term contract means it's an agreement enforceable by law, right? The term contract means it's an agreement enforceable by law. Now, when we say agreement enforceable by law, we are actually getting two things here that we need to understand. What? First, what do I mean by agreement? Right? First, what do I mean by agreement? And first, what do I mean by the term agreement? And second, what is enforceable by law? If I say in layman term, agreement is what? It's a mutual understanding between two or more people. But if we use it in the terms of law, if we understand it in the terms of law, the term agreement means what? It is, agreement is every promise and every set of promises forming consideration for each other. That is, there is either a single set of promise, a single promise, or there is a set of promises. Single promise means promise coming only from one side. Set of promises means promise coming from both the sides. And the motive is that my promise will be your consideration, your promise is my consideration. When this is present, we can say, right? Is this a problem for everyone? Two times voice is coming, something like that. Is this a problem for everyone? Dhanush, please re-log in, okay? Dhanush, please re-log in. So, what is agreement? Promise and set of promises forming consideration for each other. So, there is either a single promise or there is a set of promises. And my promise is consideration for you, your promise is consideration for me. We call it as what? We call it as agreement. Now, what do we mean by enforceable by law? What do I mean by enforceable by law? Agreement sometimes gives the parties a right to go to the court. When the agreement gives a right to go to the court, it is enforceable by law. And when it is enforceable by law, it's a contract. So what is a contract? Contract, we can form this equation. It's an agreement which is enforceable by law. Now, what is an agreement? Promise and set of promises. So, what do I mean by the word promise? What do I mean by the word promise, right? So, what is a promise? A proposal when accepted becomes a promise. When I have made a proposal to you, you accept it, there is a promise. So, a proposal when accepted becomes a promise. That means I can say that agreement is a proposal which has been accepted, right? Agreement is a proposal which has been accepted. So, it is proposal which has been accepted, right? So, that means, can I say a contract is a proposal plus acceptance plus enforceable by law, right? What is a contract? A contract is a proposal that is offer plus acceptance plus enforceable by law. This is a contract, right? This is a contract. Now, what is a proposal? What is acceptance? We will, when we come to the respective topic, proposal and acceptance, then I'm going to go into the definition of proposal and acceptance. Now, moving on to the next part. So, basically, I repeat again, what is a contract? A contract is an agreement which is enforceable by law. Now, when I use this word agreement, okay? When I use this word agreement can be a social agreement, agreement can be a domestic agreement, and an agreement can be a legal agreement, right? When I use the word agreement can be a social agreement, it can be a domestic agreement, it can also be a legal agreement. When the agreement is legal, okay? When the agreement is legal, it is enforceable by law, and when it is enforceable by law, it's a contract. So, moving on to the next part, what are the essentials of a valid contract? The essentials of a valid contract have been given under section 10. Section 10 gives us 6 essentials of a valid contract. However, over the period of time, through different cases, the court has also come across a few essentials which are considered as necessary to make a contract, right? However, over the years, the act, though act has not talked about them, but through different cases that have happened over the past years, we have come across a few conditions or essentials which are also needed to make a contract valid. And only when all of these essentials are present, though not given by the act, only when all of these essentials are present, we can say the contract is a valid contract. What are the essentials as given under section 10? Section 10 says to make a valid contract, there should be an offer and acceptance, right? There should be an offer and acceptance. There should be consideration. There should be offer and acceptance. There should be consideration. There should be capacity to contract. There should be free consent, lawful object, and agreement not expressly declared void. Apart from this, through, as I told you, through practice, through the cases that have happened in the past, the lawmakers or the court have come across a few essentials which are also needed. These are two parties, intention to create a legal relationship, then certainty and possibility of performance, and legal formality. Now, just anyway, from the next unit onwards, we are going to do all of these essentials in details as it is, but just the gist of the essentials. To make an agreement, first of all, there has to be an offer which is accepted. When an offer is accepted, then an agreement is created. Now, agreement is created, but for an agreement to become a contract, right? For an agreement to become a contract, enforceability by law is mandatory, right? For an agreement to become a contract, enforceability by law is mandatory. Social and domestic agreements, they are not enforceable by law. Only if they fulfill certain criteria or conditions, then they become enforceable by law. Otherwise, they are not enforceable by law. So, I repeat again, agreement is made, but for an agreement to be a contract, enforceability by law is also needed. So, once an agreement is made, the next thing that we need is intention to create a legal relationship, right? But most importantly, offer and acceptance happens when there are two parties, right? Offer and acceptance happens when there are two parties. Can I really, sell goods to myself, take out money from this pocket, add a little bit of profit here, put it here? Yes, I have made a profit. Can I do this? No. I need another person, right? I need another person who is going to buy my goods. So there has to be two parties. One who is making the offer, other who is accepting the offer. So when the two parties make an offer and acceptance, an agreement is made. When this agreement is enforceable by law, it is what? Then it is a contract. Correct? Then it is a contract. Now, um, once the agreement is made enforceable by law is there, but we also need certain other essentials. For example, consideration is mandatory. Correct or not? Consideration is mandatory. Without consideration, a contract which is not supported by consideration is not valid. Now don't say, but ma'am, there are lochas. No, we'll come to the lochas when we come to it. The next essential is consideration must be present, right? There should be some consideration which would support the promise of each other, because my promise is your consideration. So the next essential is consideration. Now, the parties who are contracting with each other, they should have that contractual capacity. Now, contractual capacity is not restricted only to monetary capacity, right? Contractual capacity is not restricted to monetary capacity. When I say contractual capacity, what I'm basically talking about, the person should have the ability to judge for himself whether he should make a contract or not. See, a contract is an offer and acceptance, right? A contract is an offer and acceptance. Now, you are making an offer to me. Whether to accept this or not is a decision that I make. And my mind should be in such a state where I can make this decision of whether I should contract or not. So, there should be the contractual capacity. Who is capable of contracting? A major, a person of a sound mind, and a person not disqualified by law. So if a minor or a person of an unsound mind or a person disqualified by law, if they make a contract, the contract is what? It's void ab initio. Right? The contract is what? The contract is void ab initio. Now, after this, the consent is given. So contractual capacity should be there. Apart from that, my consent should also be given by my choice. The consent that I am giving you, it should be given by my choice. If my consent is forced out of me, you put a knife here and you say tapka dunga. So that is not a valid consent, because I am not giving it by choice. So whenever the consent is given, the consent should also be given by choice. If it is not given by choice, the consent is not valid, the contract is not valid. When is the consent not given by choice, or when is the consent not free, or when is there a flaw in consent? If the consent is induced by coercion, undue influence, fraud, misrepresentation or mistake. Coercion, undue influence, fraud, misrepresentation is voidable. Mistake, depending on the situation, it may be void or valid. Right? Depending on the situation, it may be void or valid. Correct? Then after this, the purpose for which the contract is made must be lawful. See, object here, generally what we think is object is a thing. This is an object. This is an object. This is what we think. But object is not just a thing. The purpose here, the context of object is the purpose of the contract. This purpose of the contract must be what? It must be lawful. It must not be unlawful. If it is unlawful, it is what? It is void. Then, apart from that, law specifically says that a few agreements shall be considered as unlawful. The law specifically says, it should be considered as void or unlawful depending on the cases or the laws. It will be considered as these contracts are not valid. So when law very specifically says that this contract is not valid, then who are you or I to question it? Obviously the contract is not valid. So in that case also the contract will be considered as void. Then whatever the purpose of the contract is, the terms must be certain and they must be something which is capable of being performed. Whenever a contract is made, the terms of the contract must be certain and it must be something which is capable of being performed. If it is not capable of being performed, it's impossible to perform and the contract is void. And finally, legal formalities. When we talk about oral agreement is absolutely valid. Just because the agreement is oral doesn't mean law will say, nahi, not valid, take it away. No. Just because it's oral, it doesn't mean it's not valid. It's absolutely valid. But if I'm making an agreement and if it is written, I have some evidence to prove that I made an agreement. So for the evidence sake, yes, it's mandatory that it should be a written one. Evidence के लिए, it is better. I shouldn't say mandatory, it's better, beneficial to go for a written agreement. However, different acts specify for different situations that this agreement should be written or this agreement should be registered. For example, gift has to be registered. Sale of immovable property has to be registered. Insurance contracts have to be written. So when Act very specifically provides that it should be written or it should be registered, then the parties have to fulfill those formalities. Otherwise, an oral agreement is as valid as a written one. But yes, it is beneficial. I go for a written agreement. These essentials, once we are done with this types of contract, we are going to do everything in detail. So don't worry about that. Moving on. Types of contract. Now we have different types of contracts. We have three different classifications on types. Please remember, can you get a question like what are the different types of contract on the basis of validity, or what are the different types of contract on the basis of formation, or different types of contracts on the basis of performance, right? Please remember the heads also. Yeah, sure, Komal, I'll explain it. Intention to create, see, uh, even if everything is present, okay, even if everything is present, what is the motive of the parties goes a long way to suggest whether there is a contract or not, right? Even if all the essentials are present, the intention of the parties goes a long way to suggest whether there is a contract or not. Even if we have made a contract where all the essentials are present, even if we have made a contract where all the essentials are present, still the intention of the parties should also be there. That is, the intention should be there showing that we want to bind each other legally, right? So the intention, so for example, in a business agreement, it is always implied that there is a legal relationship. But even if in a business agreement, they mention that this agreement does not confer any legal rights on either of the parties. Because they have said this, even though it's a business agreement, it is still what? It is not, the intention was not to create a legal relationship. So, intention to create a legal relationship basically means that the motive of the parties in making the agreement should be that they want to bind each other legally. I hope it's clear, Komal. Now, on the basis of validity, we have five types of contract: void, voidable, illegal, unenforceable, and valid. Right? Well, Kaushik, actually, you don't carry your phone with the recorder on all the time, isn't it? And it's not always acceptable also. So on the basis of types of contract, on the basis of validity, we have void, voidable, illegal, unenforceable, and valid, right? We have void, voidable, illegal, unenforceable, and valid. What is void? Not enforceable by law. If I put it in simple terms, you cannot sue me, I cannot sue you, right? What is void? Not enforceable by law. To put it in simple terms, I cannot sue you, you cannot sue me. Now, what is voidable? Voidable contract is a contract which is enforceable at the option of one of the parties, but not at the option of the other or others. That means one party has an option to go and enforce the contract. That is, that one party who is the aggrieved party, that party has a choice that I can go to the court and I can enforce the contract if I want, or I can, that is enforce the contract as in I can accept the contract and carry on with it, or I can cancel the contract and decide not to carry on with the contract. That is, that one party has a choice, but the other party does not have any choice at all, right? So I repeat again, what is voidable? Enforceable at the option of one of the parties. So let's say fraud happens with me. I hope you remember the shirt wala example. Yes. So fraud happens with me. So I am the aggrieved party here. Now if I want, I can go and enforce the contract. That is, I can decide to carry the contract or I can decide to cancel the contract. But you don't have any rights or choice to decide whether to carry or cancel the contract. Right? The next one. So basically, if let us say A and B have made a contract which is void, A cannot sue B, B cannot sue A, right? Voidable, and let's say A is the aggrieved party. Okay, voidable, and let's say A is the aggrieved party. So A can enforce the contract, but B has no right to enforce the contract. So enforceable at the option of one, but not at the option of other or others. Now, what is valid if a contract gives right to both the parties to sue each other? Right? If a contract gives the right to both the parties to sue each other, A can sue B, B can sue A. In this case, it is what? It is a valid contract, right? In this case, it is what? It is a valid contract. So, enforceable at the option of both the parties. A can sue B, B can sue A. So, if we look at the definition, void is not enforceable by law. Voidable is enforceable at the option of one of the parties, but not at the option of the other or others. Valid is enforceable at the option of both the parties. What is illegal? Well, any act which is considered to be a crime. If you are doing any act which is considered to be a crime, it is what? It is illegal. It is void as well as punishable by law. I told you void तो it is. अगर पकड़े गए तो चक्की pieces and piecing and some more piecing, right? It is void as well as punishable by law. What is unenforceable? Basically, the word unenforceable and void are used synonymously, right? We can use interchangeably the two words, but there is a slight difference here. In void, the substance itself is not good, whereas in unenforceable, the substance is good, but there are some technical defects. In unenforceable, the substance is good, but there are some technical defects. Now, when we say substance is good, I know, I just realized this. They are just disappearing. I'll just change the color and see whether it's visible or not. Let's change the color and see. I thought I'll highlight it and it will become visible, but it is gone. Let's see if this makes any difference. I'm not using black Kaushik. It really makes no difference at all. I guess I'll have to stop using the highlighter only. My laptop, my system has become a lucha basically. There is some color issue. Oh my god, this is worse. This is worse. I guess this if this doesn't work, nothing will work then. No, I'm using yellow only. This is yellow. This is what happened when I used yellow. Yellow here is showing black. I don't know why. Ah, this is better. This I'll use this pink color. This is better. Actually, Dhanush, that is only for writing. This is not, I don't have to write anything. I need to use these, no? That is why. Chalo. Anyway, so in case of unenforceable, the substance is generally good, but there are some technical defects. And because of these technical defects, the contract cannot be enforced in the court of law, right? So this is not enforceable by law. This is enforceable at the option of one of the parties. This is enforceable at the option of both the parties. This is void as well as punishable by law. And in case of unenforceable, it is not enforceable due to some technical defects. Now, what could be the technical defects? If you remember, I just talked about where the act says, LMU, where the act says that it should be written, but you have not written, or it should be written and registered, you have only written. That is what technical defects. So, what is technical defects? Lack of writing or registration or or lapse of time. Is it clear to everyone? Yes. Now moving on to the next one. On the basis of formation, we can have contract which is express, implied or e-contract. What is express? I expressed everything. So obviously express means you told. So when we say express, express is by words. Now when I say by words, words could be oral or written, right? Words could be oral or written. So when the contract is made between the parties by words, oral or written. Yes, absolutely Varun, time bar did, correct. So it could be oral or, now when it is by words, it could be oral or written. Then what is implied? Now this implied is actually anything other than by words, right? This implied is actually anything other than by words. Now when we say implied other than by words, it could either be by law or it could be by acts, right? Anything other than by words, it could be by law or it could be by acts. When it is by law, we call it as a quasi contract. When it is by actions, we call it as a tacit contract. So, what is by law? Contract is not there between the parties, but a contract is created by the imposition of law. Contract is not there between the parties, but a contract is created by the imposition of law. What is tacit? Contract is not created by words, but by the actions of the parties. So, you stepping onto the bus or withdrawing cash from the ATM, these are all what? Tacit contracts. So, what is a tacit contract which is inferred by the acts of the parties? Whereas what is quasi? It is by law. Then the last one in this is e-contracts, that is which is entered over the internet. So, you ordering goods online, making the payment online, that is what? Using the electronic mode. Now, on the basis of formation, we may have, on the basis of performance, we may have unilateral, bilateral, executed, executory, or partly executed, partly executory, right? So, what is unilateral? Basically, it's a one-sided. Now, why do we call it as a one-sided contract? The reason being that I repeat again, why do we call it as a one-sided contract? The reason being, when the contract is made, only one party is left to perform. When the contract is made, only one party is left to perform. Why? Because the other party had already performed before the contract was made or at the time of making the contract. So, I repeat again, one-sided contract where one party performs before or at the time of the contract. And once the contract is made, only one party is left to perform. So, you booking your tickets, it's what? It is unilateral contract. You ordering goods online, cash on order. It is what? Unilateral contract. What is bilateral? Unilateral is one-sided. Bilateral is obviously both. But both have done or both are yet to do. Both are yet to perform. So, I have to deliver, you have to pay. Neither you delivered nor I paid. So, this is what? Bilateral. Both are yet to perform. What is executed? ED. When I say ED, okay. When we say ED, past tense, already done. So, both have already performed. So, both have already performed their parts under the contract. What is executory? Executory and bilateral both are yet to perform. The basic difference being there is a reciprocal promise. When the reciprocal promises, what is reciprocal promises? Reciprocal promise means it's a dependent promises. That is, performance of one depends upon the performance of the other. When it is a reciprocal promise and both are yet to perform, we call it as executory. So, cash on order, right, cash on delivery is executory. I will pay you the cash only when I get the delivery of the goods. So, this is a dependent promise, reciprocal promise, and this is what? This is executory. I hope till this point it is clear to everyone. Now, with this we are done, and now we are going to move on to the essentials of a valid contract. Before I actually move to the essentials, tell me if you have any doubt in this. I'll explain it again. Just one last thing before I end this part. Always remember, and this is a very important part, avoidable contract once ratified. What is ratified? Accepted. Cannot be cancelled, right? because for practical questions, sometimes you get this line actually is the answer to a practical question. So, avoidable contract once ratified cannot be cancelled. And also, can I say that till the voidable contract is not cancelled, it's a valid contract? Yes. Till the voidable contract is not cancelled, it's a valid contract. I hope till this point it is clear to everyone. I hope till this point it is clear to everyone. I'll just give you a minute before right? I will just give you a minute before I move forward to the next part. That is offer. Before we start with offer, I'll just give you a minute. If you have any doubts, you ask me and then we move forward. Acceptance with a retrospective effect. That is, the contract becomes valid not from the time you accepted it, but from the time the contract was made. So I guess it's clear. So moving on to the next unit, or rather next topic, or as I told you, we'll be doing all the essentials in details. So what is offer? Willingness to do or not to do something with a view of obtaining the other person's consent. Okay, yeah, sure, sure. So what is the difference between a void agreement and a void contract? See, when I say void agreement, okay, when I use the word agreement, okay, it is void ab initio. What is ab initio? From the beginning. That is, from the time it was made, it was void, right? From the time it was made, it was void. It never got the status of a contract. It was void from the time of its making. Whereas when we say void contract, it becomes void at a later stage. That is, it was valid when made. Later, it ceases to be enforceable. Right? Later, it ceases to be enforceable. It becomes void at a later stage. Please understand, though the words are used synonymously, instead of agreement we say contract, instead of contract we say agreement. But this is the basic difference. Void agreement never got the status of a contract. It was always void from the time it was made. Whereas void contract becomes void at a later stage. That is, when it was made, it was valid. But before it could be performed, changes take place, making the contract void. Under the Indian Contract Act, a contract is void only under two cases: supervening impossibility and contingent contract. All other cases, it's void agreement, right? All other cases, it's void agreement. Okay? In only in these two cases, the contract is a void contract. The rest all cases, it is what? The rest all cases, it is void ab initio. Okay? Uh, Astha, I hope it's clear. Astha, I hope it's clear. If you have any doubts, please do let me know. Okay? Moving on to the next one. Give me a minute. Okay, I guess, am I audible? Am I audible? Guys, am I audible? Huh. So now moving on to the next one. What do I mean by offer? Willingness to do or not to do something with a view of obtaining the other person's consent. Um, I repeat again, willingness to do or not to do something with a view of obtaining the other person's consent to such acts or abstinence. So basically, I am showing my willingness. Now, please understand, this willingness should be a final willingness. Okay, if I am ready to negotiate, okay, if I am ready to negotiate, it's not willingness. Willingness has to be a final willingness. If I'm ready to negotiate, it's not willingness. So, I mean, it's not offer then. It could be invitation to offer or invitation to treat an offer, a statement of intention. It could be anything. So, when I say willingness, it should be final willingness. Now, willingness is for what? It is either to do something or to not do something. So, what we understand from this is offer is not only for doing something. Even if I agree to not do something, that is also considered as a valid offer. And what was the purpose of making the offer? I made the offer with an objective that the other person will accept my offer. I made the offer with an objective that the other person will accept my offer. When all of these things are there, we can say that it is a valid offer. It is an offer. Now, when we say offer, offer can be classified under 5 heads: general offer, special offer, cross offer, counter offer, standing offer. What is special offer or specific offer? Which is made to a, obviously special or specific cannot be anyone and everyone. So what is a special or a specific offer? When the offer is made to a definite person or it is made to a definite group of person, right? What is a general or what is a special offer made to a definite person or to a definite group of person? Now, when the offer is made to a definite person or it is made to a definite group of person, can anyone accept it? No. Obviously, it can be accepted only by the person or group to whom it is made. So I repeat again, what is a special or a specific offer which is made to a definite person and can be accepted only by that person or group? What is a general offer which is made to the world at large? Now, since the offer is made to the world at large, anyone from the public may come forward, act accordingly and accept the offer. Anyone from the public may come forward, act accordingly and accept the offer. And then cross offer, when two parties are making identical offers to each other without knowing about the other's offer, it is a cross offer. So I am making an offer to sell this phone to you. You are also making an offer to purchase this phone. You don't know I have made an offer. I don't know you have made an offer. This is what? This is a cross offer. The result of cross offer is, the result of cross offer is both offers will lapse, right? The result of cross offer is both offers will lapse. Now, what is counter offer? I am making an offer to you which you modify and accept. It's a counter offer. I am making an offer to you which you modify and accept. It's a counter offer. What is the result of counter offer? Here, original offer lapses. So, since here both the offers lapse, contract cannot be made. Whereas here, since only the original offer lapses, the contract can be made. Then standing or open offer, you can have a period of time in your offer that if you want to accept my offer, accept within this period of time, right? Except within this period of time. When this is given, that except within this period of time, we call it as a standing or open offer. If you accept within this period, it's valid. If you don't accept within this period, the offer lapses. I did not get your question, Kaushik. So, what is general offer? It's made to the public at large. What is special offer to a definite person or group? What is cross offer? Identical offers made in ignorance. The result is both the offers will lapse, right? The result is both offers will lapse. So, what is counter offer? Modification of the original offer. The result is the original offer will lapse, right? Standing or open offer, which is open for acceptance over a period of time. Correct? I hope it's clear. Now, what are the rules of a valid offer? Standing offer, example, I want to sell you my car. If you want to purchase, reply by Sunday. Right? I want to purchase your car if you want to purchase, reply by Sunday. Yeah, I want to sell you my car if you want to purchase, reply by Sunday. So this is standing or open offer. I have given a time period within which the offer should be accepted. If it is accepted within that period, fine. If it is not accepted within that period, the offer will lapse. I hope it's clear, Vinu. Yashwant, we already know these offers in Flipkart and sale and all. Sale and all are not offers. They are invitation to offer, correct? So we cannot call them as standing offer because they are after all invitation to offer. So rules of offer. Now, as I told you, you obviously need to read the rules a couple of times so that you can write it in the exam. But the main thing is that you should remember, you should remember these headings. If you remember the headings and you can write then it's very easy for you, right? So you can get a question like, what are the rules of a valid offer? Yes, absolutely, I can get a question like that. And in that case, if I just remember this much, it's more than enough, right? So I mean, obviously you must have read it a couple of times, only then you can write it. Can I write a few examples here and there? Yes, absolutely. Both offers will lapse. It means both offers will lapse. So what are the rules of a valid offer? So what are the rules of a valid offer? First, an offer to be valid must be definite, clear, and not vague. So what is definite, clear, and not vague? The terms should be certain. The terms should be something that I can understand. If you give me terms which I cannot understand, how will it be valid? So when A says to B, I'll sell you 100 liters of oil at rupees 50 per liter. Is the offer valid? No. Why? Because they did not specify which oil they are talking about. So an offer to be valid the terms of the offer must be definite, clear, and it should not be vague. Then offer may be express or implied. Offer may be express or implied. What is express offer? Express offer means it is by words. What is implied? The word implied means by law or by actions. In some cases it means both, whereas in some cases it means any one. When we are talking about here offer, it means not by law but by actions. We don't have anything like offer by law. There is nothing like offer by law. We don't have offers by law. So it's either by law or by actions. But the word implied offer means by actions. Now, when I say by words, it can be oral or written. So it can also be oral or written, right? Yes, it can be oral or written. Then the next one is an offer must be communicated, right? An offer must be communicated. See, unless I know about your offer, how can I accept it? Right? Unless I know about your offer, how can I accept it? To accept the offer, I must first know about the offer. So an offer must be communicated to the offeree. Because unless the offeree knows about the offer, how will he accept it? And on this, you remember our Prem and Jenny, right? Right? Hinal, it can be anything. If it is an offer, it's not an invitation to offer. No, Hinal. I'll come to your question just in a while, okay? So I repeat again, offer must be communicated to the offeree. We all remember Prem and Jenny, right? No, even don't remember the song. Remember what happened with Prem and Jenny when Prem wanted to propose Jenny, right? Now cannot be so from this only we derive the next rule, okay? From this only, this must be communicated. From this point only we derive the next rule, which says an offer cannot be accepted in ignorance. Tell me, if I don't know about the offer, can I actually accept it? If I don't know about the offer, yes, the love guru example, correct. If I don't know about the offer, can I accept it? No. To accept the offer, I must know about the offer. So the whole process is like this. See, you make an offer to me. I come to know about it. Then I accept it. Then there is a contract. You have made an offer. I don't even know about it. How can I accept it? Can you accept something without even knowing about it? Acceptance happens when I know and then I accept, right? I don't even know how can I accept it. So an offer cannot be accepted in ignorance of the offer. That means what? To accept the offer, I should know about it. So there was a case, Lalman Shukla versus Gauri Dutt, where the person had not even made the offer. He had made the offer after the servant went off in search of the nephew. Right? When he asked the servant to search for the nephew, the offer wasn't even there. He made the offer after the servant went in search of the nephew. So, can he claim the prize money? No, because the offer wasn't even there when he acted. He did not act on the offer. Offer wasn't even there when he acted. So, he cannot accept the offer. Offer ही नहीं है तो how will I accept it? Correct? When there is no offer only, how will I accept it? So, to accept the offer, first there has to be an offer which I know about it. Even if there is an offer but I am not aware of it, I cannot accept it, because the rule is offer must be communicated. So you have made an offer. I don't know about it, but I have acted accordingly. Can I claim the prize money? No, absolutely no, because I don't know about the offer. Now, can an offer be conditional? Can an offer contain conditions? If you want to accept my offer, do this. If you want to accept my offer, make payment like this or deliver the goods like this. Yes, absolutely. It's absolutely valid. And if the offeree wants to accept the offer, he must accept those conditions subject to which the offer is made. However, it can be conditional. But if the offer says, if you don't reply within 15 days, I will deem that you have accepted my offer. This is not valid. Right? This is not valid. I repeat again, offer can be conditional. But if the offer says, if you don't reply within this period of time, I will assume or I will deem that you have accepted. This is not valid. Assume you have accepted, this is definitely not valid, because if I want to accept, I'll accept by words or actions. Silence is not accepted. And finally, an invitation to offer is not an offer. So a statement of price, a statement of intention, an invitation to offer is not an offer. So statement of intention, right? Then price tags. You can give me the names of a few that you think are invitation to offer. Price lists, pamphlets, issue of prospectus by a company, school, colleges, anything, right? Prospectus, then auction sales, discounts, then self service, correct? All of this, right? All of this is not an offer, right? All of this is not an offer. Oh yes, newspaper ads. Thank you, Vinu. I did not mention that. But tell me one case when newspaper ad is not an invitation to offer, but it is an offer. Huh? Tell me one case where it is not an invitation to offer, but it is an offer. If your reply makes a contract, it's an offer. If your reply does not make a contract, it's an invitation to offer. I say I want to sell this pen to you for 10,000. If you say yes ma'am, I agree to purchase, it's an acceptance. There's a contract. If I say I want to auction this pen, when you say I want to buy at this price, you're not making an acceptance, you're just making an offer. So it's an invitation to offer. Exactly, Rishika. Thank you. Thank you. When there is a rather missing person, rather than that, if I would say, if there is a newspaper act where there is a prize money, okay? If there is a newspaper ad where there is a prize money, then I would just say that this is an offer and not an invitation to offer. Otherwise, all newspaper ads are invitation to offer. Is it clear? Job vacancies are invitation to offer. Grooms wanted, brides wanted, vacancies, they are all invitation to offer. Right? Now, coming back to the question that Hinal had asked me. Hinal, standing offer could be to the world at large or it could be to a specific person. Anyone who finds my lost puppy in the next 10 days will get a prize money. It becomes a standing offer which is to the world at large. I want to sell you my pen. If you want to purchase, reply within 10 days. This is what? This is specific offer, standing offer made to a specific. I hope it's clear, okay? I hope it's clear, all of you. Can I move to the next topic then? This was clear. I hope you have written down all of these cases also in your books earlier also so that you don't make any errors or mistakes. So now moving on to the next part, acceptance. What exactly is acceptance? What exactly is acceptance? Now, can an offer alone make a contract? Can an offer alone make a contract? Can an offer alone make a contract? No, on that offer, I need acceptance, right? On that offer, I need acceptance, right? And only when acceptance is there, then I can say that there is a contract, correct or not, right? Only when acceptance is there, then I can say there is a contract. So, what is acceptance? When I show my willingness to the offer, it is acceptance, right? What is acceptance? When I show my willingness to the offer, it is acceptance. So what is acceptance? When the person to whom the offer is made signifies his consent thereto. When the person to whom, so see, when the offeree, that is when the person who is the offeree, the person to whom the offer is made, this shows one thing very clearly. Only the person to whom the offer is made can accept the offer, others cannot accept the offer, right? Only the person to whom the offer is made can accept the offer, others cannot accept the offer. So when the person to whom the offer is made signifies his consent thereto, signifies his consent thereto, he is said to have accepted the offer. Now, what do I mean by the word thereto? What do I mean by the word thereto? Thereto means what? Just as per the terms of the contract, to the terms of the contract, right? Just as per the terms of the contract. Now, just like offer had some legal rules, even acceptance has some legal rules. So let's understand what are the rules of what are the rules of acceptance. First and foremost, acceptance must be unconditional. Correct, Ashwan. Correct. Acceptance must be unconditional. Acceptance must be unconditional. That is, when I make an acceptance to you, it should be just as per your offer. So when I make a acceptance which is conditional, it's not valid acceptance. So let's say I applied for 100 shares of a company, but I was allotted only 60. Is this a valid? Is this a valid acceptance? Is this a valid acceptance? No. Why? Because I applied for 100 shares, but I was given only 60. Well, am I bound to keep these shares? No. But the reason I was given only 60 is because the offer is oversubscribed. That means the demand of the company is good. So when the demand of the company is good, who will say no to the shares? I'll definitely accept it. But that doesn't mean I'm bound to accept. I can actually reject and not accept it, right? I can actually reject and not accept it. So I repeat again, acceptance must be unconditional, that is, acceptance must be absolute and unqualified. Absolute just as per the terms of the offer, unqualified means not changed or modified, right? Then the next rule says acceptance must be communicated. So when we say acceptance must be communicated, communicated to whom? Acceptance must be communicated to the offerer. If you don't communicate the acceptance, ayo, I have made an offer to you. Oh, such a good offer. I accept it. But this you are not telling me. Your mind is telling you it's a good offer. I will accept. Now you go understand. Oh, ma'am has accepted my offer. Na? You go and understand. Does it happen like that? No. So acceptance must be communicated to the offerer. Now, is it mandatory that I have to go and communicate it directly? No. Can I use any via medium? Yes, absolutely. I can communicate it through anyone. But the point is that it should be communicated. Then silence would silence be considered as acceptance? Yeah. Remember the ring wala case, huh? You on your knee. Remember you on your knee. Yes. So always remember, no hasi to fasi. Always remember, no hasi to fasi. Unless and until the communication is given either by words or by actions. Yes, it can be by the act of the parties. It can be by the act of the parties, right? It can be by the act of the parties. She can just put forward a hand and tell you to just, not tell you anything, just do this. This is acceptance. But she just smiling, oh my god, oh my god. Very misguiding it is. Don't think it is acceptance. So it cannot be presumed from the silence, but it can be made by the conduct of the parties. Correct? Then it must be in the specified mode. See, if I have not given any mode, you can accept it in any reasonable mode. But if I have specified to you that it should be only in this particular mode, then if you accept my offer, it should be in that particular mode only. If I have not told you anything, you can accept it as you like. But when I have told you this is how I want you to accept, then if accepted, it has to be in that mode only. Right? And finally, must be within the time specified. And if no time is specified, it should be within a reasonable time. Right? If no time is specified, it should be within a reasonable time. I guess so. I guess so. Kaushik. So with this, we are completed with the rules of acceptance. Any doubts? Otherwise, we'll move forward. Can you hear me? Am I audible? So, I think Kaushik, I just answered your doubt when I was talking about this communication part only. I told you it is not necessarily a direct communication has to be done. It can also be done through any person. I answered this. So that is why I did not answer again because I had already answered. Okay. So moving on to the next part, communication and revocation. So, as we already talked in both the rules of offer and acceptance, both the rules had very clearly said that offer must be communicated and acceptance must be communicated. So, in both the cases, we already know communication of offer and acceptance is very mandatory. So, let's first talk about the communication part. When does the communication take place? See, if it is done through calls, okay, if it is done through the phone, I don't even have to worry. Why? Because the moment the moment the person hears it, it's done. But even if it is done over the phone, glitches can happen, right? Sometimes even our life has glitches in it. So this is through technology and internet. So glitches can happen. So even if it is made over the calls, if it is not heard by the other person, it's not a valid communication. Or if it is made over the call and it is heard by the other person, then we can say the communication is valid. So it has to be, it is very mandatory that it should be heard by the other person. However, as I told you, telephone is a very recent invention. There was a time when there was no telephone. It was kabutar ja ja chitti aayi hai. And even today also we prefer business communications to be done through letters. Why? I have some evidence, I have some proofs to go on or fall back on in case of any dispute. So mostly the communication of business letters, business for business is done through letters. So what we are going to talk about is if it is done through letters, when does the communication take place? The first thing, let's talk about, I don't know why offers communication is not given here. First, let's talk about communication of offer. Simple. I make an offer to you. When you get it, it's done. So communication of offer takes place when it comes to the knowledge of the person to whom it is made. When it comes to the knowledge of the person to whom it is made, right? So I repeat again, when we talk about communication of offer takes place when it comes to the knowledge of the person to whom it is made. But if I say communication of offer for the offerer and for the offeree, I am the offerer, I am giving you the offer. The moment I post it, it's done for me. So for the offerer, it is when he posts it. The moment I post it, it's done for me. For the offeree, it is when he receives it. The moment he receives, it's done for him. So for me, when I post it, for you when you receive it, simple. I post done for me, you receive done for you. Now, when we say communication of acceptance, okay, when we say communication of acceptance, in case of communication of acceptance, the relation is just the inverse. If I just say communication of acceptance, it's the same. Takes place when it comes to the knowledge of the person to whom it is made. Same thing. Same thing. But if I say communication of acceptance for the proposer or for the acceptor, when does it take place? Please remember, communication of acceptance is inverse, opposite. Offer is I post done for me, you receive done for you. Acceptance is inverse. For me when you post it, for you when I receive it. The point is that once you have posted your acceptance, my offer is sealed. I am bound by my offer and I cannot make any changes to it. So it takes place for me. The point is that the moment you receive, right, the moment you receive the acceptance, the moment I receive the acceptance, there is a contract and you are sealed by you're bound by your acceptance and you cannot revoke it. And that's the reason it's opposite. The moment you post, my offer is sealed, I cannot revoke it, it's done for me. The moment I receive, there is a contract and your acceptance is sealed and you cannot do anything with it. That is, you cannot change it, so it's for you. So for the proposer, it is when the acceptor posts the letter. For the acceptor, it is when the letter reaches the proposer. I hope it is clear to everyone. I hope it is clear to everyone. They come with a time period, no? So you have different with a prize money, right? A definite prize money. So it's a definite prize money here, and you get those subscriptions for a limited period of time. So it is for a particular, so acceptance is not restricted to a time period. When acceptance is restricted to a time period, then we say it's a standing offer. Do they say if you take the subscription within the next 10 days only, then it's available, after 10 days it's not available? No. So how can it be standing offer, right? The performance period is restricted. If you have taken 1 month subscription, the performance period is 1 month. If you have taken a 1 year subscription, the performance period is 1 year. The performance period is restricted depending on the type of subscription that you have. Now, rescission. What is rescission? Rescission means to cancel, right? Rescission means to cancel. When after I have made the offer, or after I have made the acceptance, I want to cancel it. Can I cancel my offer or acceptance? Can I cancel my offer or acceptance? Yes, I can cancel my offer or acceptance, right? Now, communication of rescission is as mandatory as communication of offer or acceptance. Now, you are canceling your offer or acceptance. Do I get a dream? Cancellation is done. No, you have to tell me about it, right? I am sorry, Purvi, but I did not. Wow. You seriously have got your, mind process racing like crazy, coming up with these ideas. It depends. If he has already communicated his acceptance and then he's just talking and dies, acceptance is done. If he dies before communicating his acceptance, the acceptance is done. I'm also getting all the. See, Purvi, every offer comes with a timeline. A timeline, when it is specified, it is standing. When no timeline is specified, you have to anyway accept it within a reasonable time. Discounts are not offers, Purvi. I just explained it to you, right? See, discounts are invitation to offer. There is no halfway, right? There is no halfway. He cannot I X and die, right? It's not accepted. Purvi, I hope you got it. Now, anyway, moving on to rescission. That is, once I have made an offer or acceptance, I want to cancel it. That is what? That is rescission, cancellation. Communication of rescission is as mandatory as communication of offer or acceptance. Communication on rescission is simple. If I am revoking against you, for me when I post it, for you when you receive it. If you are revoking against me, for you when you post it, for me when I receive. Simple. I post done for me, you receive done for you. Vice versa. You post done for you, I receive done. Right? So, so I repeat again, communication of rescission. If I am revoking against you, for me when I post, for you when you receive. If you are revoking against me, for you when you post, for me when I receive. So, for the person who makes it, for the person who makes it, it is when he posts it. For the person against whom it is made, when he receives. Right? Now, what is the time of revocation? What is the time of revocation for offer? What is the time of revocation? Remember, till the time acceptance letter is not posted, offer can be revoked. But once the acceptance letter is posted, offer cannot be revoked. Remember, till the time acceptance letter is not posted, offer can be revoked. But once the acceptance letter is posted, offer cannot be revoked. Right? So, offer can be revoked if the letter reaches before the acceptance letter is posted. Once the acceptance letter is posted, offer cannot be revoked. Acceptance is to offer what a lighted match is to a trail of gunpowder. There is a trail of gunpowder, you put a lighted match to one end of it. Now, even if you remove the rest of the gunpowder, the blast will take place. Similarly, there is an offer, and on that offer, you give your acceptance. The moment you give your acceptance, there's a contract. Now, nothing can be done. Right? So offer can be revoked if the revocation letter reaches. Just posting is not enough, it should be received. Similarly, you have given me your acceptance. Once I've received your acceptance, okay, once I've received your acceptance, there is already a contract. Contract is already made now. How can you revoke it, right? You have given me your acceptance. The contract is already made. If I receive it, how can you revoke it? So, if the revocation letter reaches before the acceptance letter reaches, right? Reaches before. This reaches is very important. Just posting isn't enough. It should be received. Reaches before the acceptance letter is received. Is it clear to all of you? And though we have done this question so many times, but still, because this is something to do with dates, we get so confused with this. So I still want you to solve this question once before I move forward. Okay, okay. I'm so sorry. I did not realize. Now is it visible? I'm so sorry. I did not realize it. Now it should be visible, I guess. Be a little quick, okay? Be a little quick to solve the question. There are a lot of people there in the class, but only a few handful of you are messaging. I expect everyone to drop a message on this question. I want everyone to drop a message of, giving the answer to this question. Okay. Offer is communicated. Will complete. Correct. Then, see, you give the answer, then I discuss, right? Everyone is supposed to. There are so many of you. Everyone is supposed to give the answer, not just a few handful of you, right? Mr. B makes a proposal to Mr. S by a post to sell his house for 10 lakh and posted the letter on 10th April. And the letter reaches S on 12th April. He reads the letter on 13th April. Obviously, if this was not given, this would have been the date. But since this is given, communication of offer takes place here. Mr. S sends his letter of acceptance on 16th April and the letter reaches Mr. B on 20th of April. On 17th April, on 17th April, Mr. S changed his mind and sends a telegram withdrawing his acceptance. Telegram reaches on 19th. So, before 20th April, if the revocation of acceptance is done, it is valid. Right? So, on what date is the offer complete? 13th. Can we say it's not valid because it has been revoked on 19th April? Yes. If both reach together, since it's a telegram of revocation, revocation is absolute. Since it's a telegram of revocation, revocation is absolute. I guess it's clear. Most of you have given the correct answer. Penal, your answer is not correct. Did you understand, dear, why your answer is not correct and why this is the correct answer? Did you understand that? If both of them are reached or received together, since it is a telegram of revocation, revocation is made by telegram, revocation is absolute without any doubt. So it is revocation which is valid. Hinal, your answers were wrong. Did you get it why your answers are wrong? In the given situation, they have asked you to view the validity of the acceptance. So you cannot, they are not asking you till what time if it was received it would have been valid. That is not the question they are asking you. They are asking you in this scenario, is it valid? Correct? So we have to answer on the basis of this scenario. Correct? Chalo. So, moving on to the next one. This is done. I hope everyone has understood communication and revocation and offer and acceptance. Yes. Moving on to the next part. The next essential is what? Consideration. Technically known as quid pro quo. And what is quid pro quo? It means something in return. It's not anything or everything, it is something in return. That is, when I give you something, I should get something in return, and what I get in return is my consideration, right? So, so what is consideration? Something in return is just a technical word of saying it. It's not the definition of consideration. So when I look at the definition, what it says, when at the desire of the promiser, the promisee or any other person had done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. When at the desire of the promiser, the promisee or any other person had done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. So, if I look at this definition, I get the rules of consideration also. Each act or abstinence form consideration for each other means what? My act is your consideration, your act is my consideration, or my act is your consideration, your abstinence is my consideration, or my abstinence is your consideration, your abstinence is my consideration. Could be anything. So acts or abstinence becomes the consideration for each other, right? Acts or abstinence becomes the consideration for each other. Um, Now, what are the rules of consideration? What are the rules of consideration? First of all, consideration must move at the desire of the promiser. That means whoever I'm doing the work for, his desire should be there that I do the work for him. Whoever I'm doing the work for, his desire should be there that I do the work for him. If his desire is not there, can I sue him for consideration? No. If his desire is not there, can I sue him for consideration? No. Consideration must move at the desire of the promiser. However, consideration may move from the promisee or any other person. That is, if instead of you, someone else performs, it's absolutely valid. The whole point is I should get consideration. It is immaterial who is giving the consideration. That means I can say that there can be a stranger to consideration. That means I can say that there can be a stranger to consideration, right? There can be a stranger to consideration. That is, a third party can give consideration. I hope it's clear to all of you. Yes. Now, the next one, the next one. So I repeat again, the first rule, consideration must move at the desire of the promiser. Consideration may move from the promisee or any other person, right? Then consideration may be executed or executory. What is executed? What is executory? Executed means an act already done, right? An act already done. Executory means an act yet to be done. Now, when we say yet to be done, that means what? A promise has already been made, right? That means what? A promise has already been made, but it is yet to be performed, right? An act yet to be done means what? A promise has already been made, but it is yet to be performed. An act yet to be done. Now, consideration. So, let's say I have delivered the goods, but you are yet to pay. So, my work is done, your work is yet to be done. Mine is executed, yours is executory. Then, consideration may be past, present, or future. What is present consideration? Something which is going on. What is future? Which will be done. What is past consideration? Previous request and subsequent promise. That is, I first ask you to do the work, and after the work is done, I promise to compensate, right? I first ask you to do the work, and after the work is done, I promise to compensate. This is what? This is this is past consideration. Previous request, subsequent promise. Because it's out of gratitude that I am paying, under the English law, they say it's not valid, but under the Indian law, it's absolutely valid. Then in every contract, consideration must be present. Okay, in every contract, consideration must be present, but there is no rule which says that consideration must be equal. Consideration must be present, however, consideration need not be equal, right? The basic logic is that consideration is always detrimental to one. Consideration can never be beneficial to both the parties. It is always detrimental to one. It can be detrimental to both. That is at a loss to both. But it is never beneficial to both. So consideration need not be adequate. And just because consideration is not adequate, you cannot cancel the contract on that grounds. You cannot cancel the contract simply on the grounds that consideration is not adequate. You cannot cancel the contract simply on the grounds that consideration is not adequate. And then in every contract, consideration is generally paid to the other party. Now tell me, now tell me, um, when I talk about consideration, if a person is already receiving a legal fee for doing a particular work, right? See, partnership, Indian Contract Act, Sale of Goods Act revision I will do. If you want revision for Companies Act and LLP, pay me fees. Can I ask you for that? Can I ask you for that? Can I ask you for that? No, because it's already my obligation to do that work, right? It is already my obligation to do the work. So if a person is already receiving a legal fee to do a particular work, and for that same work, if he claims something extra, for that same work, that extra is what? That extra is void. If he claims something extra for that same work, that extra is void, right? So consideration must be something which a promisor is not already bound to. Excuse me. Consideration must be something which a promisor is not already bound to do. But if the person does anything which is outside his duty, are you liable to pay him for that? Yes, and that is absolutely valid. And last, consideration must not be unlawful, illegal, or against public policy. Correct? Must not be unlawful, illegal, or against public policy. Okay? So, moving on to the next one. Are all the rules of consideration clear? Anyone has any doubts in this? Are the rules of consideration clear? Anyone has any doubts in this? Chetan, since it's a marathon, I cannot even tell you this is the end time of the class. It will go on as long as the marathon. Correct? Anyone has any doubts in this? You tell a policeman, I will pay you money, please catch the robber. You don't have to pay money to catch the robber, it is the work of the policeman. Any other doubt you have? Now, the next one, privity of contract. So, what do I mean by privity of contract? What do we mean by privity? Privity means privacy. Correct? What is privity? Privity means what? Privacy. Listen carefully. A and B have made a contract. Can C sue this contract? Kaushik, no offense, but अगर वो मन की बात होती, I wouldn't have been. So tell me, A and B have made a contract. Can C enforce the contract? Can C enforce the contract? No. No, who are you? Right? Who are you? If A wants to sue B, A will sue B. If B wants to sue A, B will sue A. Who are you? Correct? Who are you? So can C enforce the contract? Absolutely no. Acha, tell me, but can C give consideration to this contract? Can C give, huh? Can C give consideration? Yes. Yes. Third party can give consideration, but third party cannot enforce the contract, right? So the general rule is that only the parties to the contract can sue and be sued, third party cannot sue, right? Only the parties to the contract can sue and be sued, third party cannot sue. लेकिन लॉ में क्या होता है? लोचा. So there are cases where a third party can sue and it's absolutely valid. So what are these cases? The first one, in case of a trust or beneficiary. If you are named as a beneficiary of a trust agreement, okay? If you are named as a beneficiary of a trust agreement, can you enforce the contract? Can you enforce the contract? If you are named as a beneficiary of a trust agreement, can you enforce the contract? Yes, even though you are not a party to the contract, if you are a beneficiary of a trust agreement, you can enforce the contract. Right? Now, if you are a beneficiary of a family or a marriage settlement, okay? If you are a beneficiary of a family or a marriage settlement, can you enforce the contract? If you are a beneficiary of a family or a marriage settlement, can you enforce the contract? Yes. Even though you're not a party to the contract, being a beneficiary, you can enforce the contract. Then, if the rights of a contract are transferred to you, okay, if the rights of a contract are transferred to you, can you enforce this contract? Yes. Even though you are not a part of the original contract, when the rights are passed on to you, assigned to you, you can enforce the contract. Then, if a third party acknowledges his liability, right? If a third party acknowledges his liability, so when he acknowledges his liability, we can go and sue the third party even if we had no contract with that third party. And the last one, covenants running with the land. What is covenants? Covenants means agreements. We can have certain specific agreements relating to land. When a party enters into a contract subject to these agreements, right? When a party enters into a contract subject to these agreements, then in that case he is bound to perform them. And if he doesn't perform them, the third party or whoever is named as a beneficiary of this agreement can enforce the contract. Is it clear to everyone? Yes. Any example you want me to explain? See, it's a revision as I told you, so obviously we'll be going at a fast pace. If you have any doubt in any of the examples, you can ask me before we move. Done? Now, we already discussed that consideration is one of the essentials of a valid contract, right? Consideration is one of the essentials of a valid contract. In fact, okay. Yes, Purvi, yes, Purvi. In fact, if consideration is missing, the contract is void ab initio, right? If consideration is missing, the contract is void ab initio, right? If consideration is missing, the contract is what? The contract is void ab initio. However, there are certain cases where without consideration also the contract is valid, right? Now, before I go into this, you people had asked me some examples to explain. I'll just go for that. First, assignment. Okay, what is this assignment? A has to pay B 10,000. Can we say A has a right, B has a right to receive and A has a liability to pay? Yes, A has to pay B 10,000. A has a liability to pay and B has a right to receive, right? A has a liability to pay and B has a right to receive. Now, B says to A that please don't pay this money to me, rather please pay it to C. Please pay this to C. So he asks A to pay the money to C. So when he says don't pay it to me, pay it to C, what has he done? He has assigned his rights to C. Right? Now if C does not get the money, can C enforce this contract? Can C enforce this contract? Yes. In that case, C can enforce the contract. Right? One more thing here, agency. Let us say A purchases a land from O on behalf of P. Okay? A purchases a land from O on behalf of P. Now the contract is between A and O, right? The contract is between A and O, but the land has been purchased on behalf of P. Now later O refuses to perform. So when O refuses to perform, can P go and sue this contract? Yes. Even though he is not a party to the contract, he can enforce the contract. I hope it's clear to everyone, right? So these are the two cases that you wanted me to explain in details. Is there a problem with the voice? Is there a problem with the voice? Is there a problem with the voice? Chalo, moving on to the next one. No consideration, no contract. No consideration, no contract. If I keep giving you 5 minutes after every 20 minutes, you will not finish the marathon. You will not finish the marathon, in 2 days. Is there a problem with the voice? Voice is okay, I guess, right? Go, you if you anyone wants to attend nature's call, go and attend nature's call, and then we'll continue. Okay, am I audible, guys? मेरी आवाज आ रही है. Yes. So, can you hear me? Now, general rule is a contract without consideration is void because a contract without consideration is. Damini, you wanted me to explain estoppel. Lunch will take around 3 o'clock. We'll take a break for lunch. Okay? So, Damini, you wanted me to explain estoppel. Yes? Yes? You wanted me to explain estoppel. Anyway, Damini had messaged me estoppel. Okay, anyway, I'll explain it. So, let's say A sold his goods to B. Okay? S sold his goods to B. But the goods are with A, which are with A. So I repeat again, S sold his goods to B, which the goods, but goods are with his agent A, right? But the goods are with his agent A. So I repeat again, S sold his goods to B, but the goods are with his agent A. He says to his agent that please deliver the goods to B, right? He says to his agent A that deliver the goods to B. Now what the agent does is, agent calls up B and says that I have your goods, I am going to deliver them to you, right? I have your goods and I am going to deliver them to you. The moment he says this, I have your goods and I'll deliver it to you, can we say he has acknowledged his liability to B? Can we say A has acknowledged his liability to B? Yes. Now if B does not get the goods, can B sue A? Yes. Can B sue A? Yes. Is it clear? I hope it's clear. Now, moving on to the next point, as I told you, the general rule is no consideration, no contract. A contract without consideration is void. Contract to be valid must be supported by consideration. That is, when I give you something, I should get something in return. If there is no consideration, the contract is void, right? If there is no consideration, the contract is what? The contract is void. Correct? If there is no consideration, the contract is void. No problem, Damini. I hope you've understood. Yeah? So, however, law में क्या होता है? लोचा. That means there are cases where without consideration also the contract is absolutely valid. So, what are these lochas? The first one, right? Guys, I mean the girls especially. Girls, your husband will give you all these dialogues. Johnny Bahar, Johnny Jigar, Johnny Tamanna, Meri Chamak Chalo. Remember, I will gift you a diamond necklace. Don't be happy. Oh my god, he is gifting me a diamond. No, same. Wait, bhaiya. I mean, Saiya. Give it in writing. Get it registered. And then if he doesn't give it to you, go and sue him. That means what? If it is made out of love and affection, the contract is valid if it is written and registered. Your dad telling you, you pass your CA exam in the first attempt, I am going to give you 5 lakh rupees. You so super happy. My starting of my career with 5 lakh in my bank. Oh, yo, full happy. That was the, motivational force for you that I have to clear all my exams. All 3 exams cleared in the first level, first attempt only. All my exams done. I am done, ready. Now what happens is, now you have become a CA, all the 3 attempts cleared in all the 3, levels cleared in the first attempt. Go to dad, give me 5 lakh. Yes, my dear son. Now see, you will take a job, you will earn, you will give me money. I will save. The first 5 lakh I save belongs to you only. कुछ नहीं मिला. all gone. दिल के अरमां में बह गए, gone, money gone. Can you go and sue your dad? Tell me, guys. Can you go and sue your dad? Obviously, no. Why? It was just a domestic agreement. So, unless the agreement is written and registered, it's not valid. Clear? Then, compensation for past voluntary service, right? Compensation for past voluntary service. Now, you have rendered voluntarily services for another person, right? You have rendered. For now, the motivation is, for clearing your CA foundation exam. There is no 5 lakh rupees here. But the motivation is, you don't want to go through all of this again. Right? You don't want to go through all of this again. You want to study the next part of Companies Act. Yes or no? That should be the motivation to go and clear your foundation in the first attempt. Correct? So, compensation for past voluntary service. From the name only we are getting everything. The services were rendered voluntarily. The services have already been rendered and the promiser promises to compensate. Right? The promiser promises to compensate. If all these conditions are fulfilled, it's a valid contract. Right? So the services have been rendered voluntarily. The services have already been rendered. Promiser is in existence and the promiser promises to compensate. Correct? If all these conditions are fulfilled, it's a valid contract. So, a person drowning and you find, you help him, you drag him out of the water, you save his life and he promises to pay you 100 rupees. And I told you, all of you who are thinking I'm going to throw him back, it was a charity you were doing. Don't do that. This is what? Past voluntary service. If he doesn't give you the money, you can actually sue him to recover that money. The next one, time barred debt. What is a time barred debt? It is a debt which is irrecoverable by law and the time as given under the Limitation Act is 3 years from the day the loan is repayable. Right? So let us say this is the day the loan is repayable and from this day we have a period of 3 years. Right? We have a period of 3 years. If up to 3 years the debtor has not paid the money and the creditor has not recovered the money, the debt becomes time barred. So let us say on 1/4/2019 the debt was repayable. So 3 years means on 2/4/2022 it becomes time barred, that is irrecoverable by law. Now the creditor cannot sue the debtor on this amount anymore. Right? Now the creditor cannot sue the debtor exactly like now. Cannot sue the debtor. See, answer. When you answer no, it boosts up your confidence. All of you who are sitting in the class answer. When you answer, when you are able to recall, it's boosting your confidence that yes, I know I can actually write my exam, right? So on 2/4/2022 it becomes irrecoverable by law. That is, now you cannot sue to recover this money. But if I am talking about this period now, I am not talking about during this. No, I am talking about this period. If during this period the debtor or his agent they give a written promise to pay a time barred debt, it's again a valid contract, right? It is again a valid contract. I hope it's clear to all of you. Yes. Moving on to the next one, agency. Right? Moving to the next one, agency. What is agency? When a person acts on behalf of another, right? When a person acts on behalf of another, you have done that so many times for your mom, for your dad, for your friend, for your siblings. The siblings is the worst kind. We never do it unless we are literally like no option, but we have to do it. Otherwise, every time my sibling asks me to do something for them, I would just remind them, remember I asked you for a glass of milk. Did you give me a glass of water? No. Anyway, this is the reality of life actually. Correct? Now, agency, when we talk about agency, if an agent does the work for the principal, obviously he is paid money. But there may be a situation where he may not be paid any consideration. And even if, I'm not saying don't pay consideration. obviously he's doing the work for me, I should pay consideration. But even if no consideration is paid, it is still valid, right? Even if no consideration is paid to the agent, it is still valid. The agency is still valid. Is it clear? Yes. So even if there is no consideration, it's absolutely valid. Then completed gift. See, if it was only gift, see, if it was given only gift, it could be just a mere promise also. But completed means the gift is already given, right? Right? The gift is already given. So when I say gift, I'm not talking about just gift. Gift could be a mere promise. Completed gift means the gift is already given. I've already given it to you. Once I have given it to you, can I claim it back? No. You promise your friend, hey, it's your birthday, I'll give you 10,000 cash. No cash coming. You only not visible. Midnight gone. Khatam. You disappeared from the what? From this, the surface of the earth. Gone. You came back, resurfaced only after the birthday went. Can he sue you? Hey, you promised me 10,000. Give me. No. But you gave the money. Now, after the money was given, the next day you go, you to have so much of money. I urgently need money. Give me the money back. No, will he give it back to you? Huh? Will he give it back to you? No. Once the gift is given, it is an absolutely valid contract. Once the gift is given, the contract is valid. So it's completed gift. Once the gift has been given, it's valid. Charities and donations. If you just make a promise to give charity or promise to give donation, not enforceable. But on the basis of your promise, if the other person has incurred any liability, he can recover to the extent of liability. Right? And finally, bailment. Bailment is when I give the possession of my goods to another for a specific purpose, and once the purpose is attained, the goods are either returned back or disposed of as specified. In case of bailment, consideration may or may not be given. For example, you lend a book from the library, you have to pay money, annual fee or yearly fees or monthly fees, whatever. But if you lend a book from your friend, you don't have to pay him anything. Both are bailment. In one, consideration is paid, and another it's not paid. And even if it is not paid, can you with that book do? He loves me. He loves me not. You cannot. It is your obligation to return the book back. Yes? Just a promise to gift is not enforceable, but once the gift is given, it's a valid contract. I hope it's clear to all of you. Okay, do you have any doubts, or can we? Okay, Varun. So let's say, what exactly is bailment? Let's say I give you the possession of my goods for a purpose. I want to deliver the goods to a person in Mumbai. I give you the goods, please deliver it to that person in Mumbai. Contract between you and me is bailment. I have a puppy, I'm going out for vacation, cannot take care of the puppy, ask you to take care of my puppy till I'm out for my vacation. Contract of bailment. Now, when I give it to the carrier, he is going to charge me money. When I ask my friend to take care of my puppy, he is not going to charge me any money. But either way, both the cases, I have to return the goods back. So, what is bailment? Bailment is where the possession of the goods is transferred. Why is it transferred? For a specific purpose, right? Why is it transferred? For a specific purpose. And once the purpose is attained, the goods have to be disposed of, or returned back as is specified. Is it clear to everyone? I hope it's clear to everyone. Yes. Now, can we move to minor's agreement? Now, the next is capacity to contract. So, when we say capacity to contract, who is not capable of contracting? A minor, right? A minor is not capable of contracting. Then a person of an unsound mind, a person of an unsound mind, and a person disqualified by law, right? And a person disqualified by law, they are not capable of contracting. And if they contract, the contract is void. Kaushik, when it is very specifically given written, do I need to answer that? Now, what is disqualified by law? What do I mean by disqualified by law? Who is a person who is disqualified by law? Um, an alien enemy, right? A convicted. I'm saying convicted. I'm not saying criminal. Convicted criminal, right? Then insolvents. Then company against its MOA. So company's MOA empowers the company, says that the company can do this or the company can do that, and the company cannot do anything other than that. Any contract where the company makes any contract which falls outside this MOA is what? It is void, right? Company against its MOA. Then foreign sovereigns and ambassadors, when we send them outside the country to represent our country, we give them powers that this is what you can or cannot do. If they make any contract which is outside these powers, it is what? It is void. Then unsound mind. Next, no, Teju, absolutely no. There will be no deduction of marks just because you have not written the section. There is no rule that if you don't write the section, your marks will be deducted. Okay. So, moving on to the next one, unsound mind. What do I mean by unsound mind? A lunatic, a person under the influence of drugs or alcohol, or a person who is in a delirious state of mind due to illness. Now, if a person who is of an unsound mind enters into a contract, the contract is obviously void ab initio. Now, if a person has both periods of sanity and periods of insanity, he has lucid intervals as well as unsound intervals. A person is generally of an unsound mind, but इसको कुछ झोंके आ जाते हैं soundness के, has certain lucid intervals, and he makes a contract during those lucid intervals. What happens? The contract is valid. And on the other hand, a person is generally of a sound mind, but उसको कुछ दौरे आ जाते हैं unsoundness की. He has certain unsound moments, and he makes a contract during those periods. The contract is void. The moral of the story is, if you are sound, make a contract. If you are unsound, don't make a contract. Now, moving on to the next one. When I don't even move, when I want to scroll up my screen, no, it will get stuck. It will not move. And if I don't want to scroll up my screen, even if I touch, it will move. So moving on to the next one, minor's agreement. First rule says an agreement with a minor is void, right? An agreement with a minor is void. So if I have made a contract with a minor, I cannot enforce the contract because the contract is what? The contract is void. However, minor can be a beneficiary. If I want to sum up this two line, it means if a contract is made with a minor and the minor breaches the contract, we cannot sue the minor. But if the other party breaches the contract, the minor can sue the other party. That means if I sum up this, a minor cannot be sued, but a minor can sue, right? A minor cannot be sued, but a minor can sue. Then moving on to the next one, a minor can always plead minority. He can always plead minority. If a minor fraudulently enters into a contract, let's say he's a minor but he says I'm a major and makes a contract. If a minor fraudulently enters into a contract and the contract is cancelled, then he can prove the fact that he is a minor. And if he proves the fact that he is a minor, the contract is discharged because contract with a minor is void. However, if the intention of the minor was to cheat, okay, if the intention of the minor was to cheat, even if he proves his minority, he will have to compensate. Even if he proves his minority, he will have to compensate the other party. So I repeat again, a minor can always plead minority, but if the intention of the minor is to deceive, even if he proves his minority, he will have to compensate. Then a minor's act cannot be ratified. A minor, on attaining majority, he can enter into fresh contracts, but he cannot ratify the old contracts of his minority. A minor's act cannot be ratified. That means he can make new contracts, but he cannot ratify the old contracts. Any contract. Now, if the guardian of a minor contracts on behalf of the minor, if a guardian of the minor contracts on behalf of the minor, if it is beneficial for the minor, it is valid, right? If it is beneficial for the minor, it is valid. If it is not beneficial, it is not valid. If the guardian is appointed by the court and he enters into a contract with the sanction of the court, then every contract is valid. Obviously, sanction of the court is taken. So when the sanction of the court is given, we don't question the validity of the contract is obviously valid. A minor is never personally liable. Now, if a person supplies necessaries to a minor, it is not that the minor will grow up, earn and then repay. No. If the minor has properties, we will be reimbursed from the minor's property. But if the minor has no property, we will not get back anything. So a minor is not personally liable for the necessaries supplied to him. The liability is against his property. Now, a minor cannot be a partner. He can be admitted to the benefits of the firm. A minor cannot be a member of a company except by way of transfer or transmission. He can be a joint promiser, but except him, all others will be liable. He can be an agent, not a principal. And if he is a principal, what will happen in that case? The agent is personally liable. He cannot be declared as an insolvent. If any person gives a guarantee on behalf of a minor, the guarantor, that is the surety, is personally liable, right? The surety is personally liable. A minor cannot be a partner of the firm, however, he can be a beneficiary. Minor can be an agent but not a principal. Then a minor cannot be declared as an insolvent. The rule of estoppel does not apply on a minor because he can always prove his minority, right? If he says I am a major and makes a contract, in future he can say no, I was a minor, and the contract will be discharged. Why? Because the contract with a minor is void. That means estoppel says you cannot deny what you have said, but when a minor says I am a major, he can in future deny and say that I am not a major, I am just a minor. Alright, so minor shall be liable for torts except for breach of contract. Now, when the intention of the minor was to cheat, he will have to compensate. He will have to compensate. That means we can ask the minor to compensate if he has cheated the other person. So, he is liable for tort. But as I told you, the first point, if the minor breaches the contract, right? If the minor breaches the contract, I cannot sue the minor, but minor can sue us. So, he is not liable for breach of contract. He may be a joint promiser and except him, all others will be liable. He cannot be a member of the company except by way of transfer or transmission. And even in that case, the shares have to be fully paid up, right? The shares have to be fully paid up. Tort is a civil wrong. Now, if any person has given a surety on behalf of the minor, the surety will be personally liable, right? If any person has given a surety on behalf of the minor, the surety will be personally liable, and the parent of a minor is liable for the acts done by the minor only if they have authorized the acts, right? Only if they have authorized the acts. I hope it's clear. Any doubt you have, you can tell me please first. We are done with capacity to contract. Any doubts you have? Yes, Kaushik. Parents are not liable. You want a lunch break now? Because we have completed this topic. Before I start with the next topic, you want a lunch break now? You want a lunch break now? Because we have completed this topic. Before I start with the next topic, you want a lunch break now? No one else is answering, huh? No one else is answering. No one else is answering, huh? No one. In this also, we cannot come to one decision. Some will say yes, some will say no. Without any authorization, you have become the official representatives, huh? Okay, chalo, we'll take a lunch break. I will see you all at 3:15 is okay? No, I will not be back by 3. So 3:15? Okay? I'm giving you a 30 minutes break. What? 30 minutes is not enough, Kaushik. Are you going to cook and eat or you're just going to eat, huh? Well, I'll see you all at 3:15. Yeah. I'm not stopping this video, okay? I'm not stopping this video. This video will go on. Well, I'll see you at So I guess you all are back. Hello. Okay, so did you all eat properly? Did you eat well? Okay. Hello. So we'll start with the class now. I hope you did not overeat because that would kind of make you drowsy. So the next essential was free consent. We had done till capacity to contract. The next essential is free consent. Now, in every contract, consent must be present and this consent must be free. Right? In every contract, consent must be present and this consent must be free. Now, good afternoon, Kaushik. Yes, yes, I had. When is the consent not free? That is, when is there flaws in consent if it is induced by coercion, undue influence, fraud, misrepresentation, or mistake. Right? So these are the cases where the consent is not free. So let's understand each of this. What is coercion? First, let us understand what is coercion. Munna Bhai saying, if you don't sell me your bike, right? If you don't sell me your bike for 5,000, tapka dunga. Now, at that point of time, obviously, what will you do? Will you say, no, I will see how you tapka me? Will you do this? Will you do this? Don't. Don't. Give him the bike. This is what? Coercion. So, what is coercion? Where one party threatens the other to enter into a contract by an act which is a crime. Right? Right? Yeah, absolutely. Where one party threatens the other, right, to enter into a contract by an act which is a crime. See, sometimes I have a right to hold a property, right? When I have a special right over that property, I have given you a loan against the security of the property. I have a right to hold the property. When I have a right to hold the property, okay, when I have a right to hold the property, it is what? It is lawful detaining. But when I don't have a right to hold the property, but I still hold the property to force you to contract, It is what? It is unlawful detaining of the property. Correct? It is unlawful detaining of the property. And in case of unlawful detaining of the property of another, this is also what? This is also coercion. Right? This is also coercion. So what is coercion? Threatening to commit a crime or unlawful detaining of the property of another. The force is a physical force and can be by or on a third party. Right? Can be by or on a third party. You go to a money lender who's your friend, he says, yes, sure, I'll give you loan, but you have to give me 100% rate of interest. Undue influence. Make sure you take tuitions from me. Otherwise, the next 5 years, class 12 boards is just a dream for you. Undue influence. Right? What is it? Undue influence. Correct? Correct? Undue influence. You are an ardent follower of a religious guru. Baba jo bole satya vachan. Baba says transfer all your property in the name of my trust. I will transfer. You will in this life you will definitely attain salvation. Undue influence. So in all of these cases, there is a relationship between the parties, right? In all of these cases, there is a relationship between the parties, right? So there is a relationship. And whenever we say relationship, obviously there is a dominating position. Now, very specifically, the Act has given that dominating position happens when there is a real or apparent authority, or there is a fiduciary, that is a relationship of trust authority, or there is what do you say, mental distress, right? There is mental distress, or there is unreasonable terms of the contract. In all of these cases, they say that there is a dominating position, right? In all of these cases, they say that there is a dominating position. And I'm using it to enter into a contract on terms which are unreasonable. It is what? It is undue influence. The force is a mental or a moral force, and it can be only on the parties. Correct? It can be only on the parties. I hope it's clear, everyone. Yes. Now, the next one, ayo, fraud. What is fraud? Dhoka, cheating, mosa, whatever you say, right? Dhoka, cheating, mosa, whatever you say. Fraud has been defined by law under 5 categories. Okay, right? I repeat again. Fraud has been defined under 5 categories in law. What? Making a wrong statement, not saying something that you should say, making a wrong statement, not saying something you should say. So please understand, fraud is not just giving a wrong statement, not saying something that you should say is also fraud. When a party has made a contract without an intention to perform, this is also fraud. So these are the first 3 categories: making a wrong statement, not saying something that you should say, or parties have made a contract without any intention to perform. Now, if law says this is fraudulent, then who are you or I to question? So when law declares something to be fraudulent, and the last one, which is an open-ended point, we need to be careful. Otherwise, what will happen if we are not careful? It may so happen that it does not fall under any of the above categories, and it is a fraud, but still we cannot punish. So for that, they have kept an open-ended point. Any act which is done with an intention to deceive is fraud. So what is fraud? Suggestion as to fact of which is not true, but the person believes it not to be true. That is making a wrong statement. Intentionally making a wrong statement. Concealment of facts. Promise without an intention to perform any act to deceive. And yes, any act declared fraudulent by law. Any act declared fraudulent by law. Right? Now, the general rule is that silence is not fraud. The general rule is that silence is not fraud. So silence is not fraud. लेकिन लॉ में क्या होता है? लोचा. So there are cases where silence is considered as fraud. There are cases where silence is considered as fraud. So what are the cases? When it is the duty of the person keeping silent to speak. So normally I don't have to speak up. But there is a special situation which demands that I should speak. If in that special situation I'm silent, then silence is fraud. Normally I don't have to speak up. Normally, I don't have to speak up, but there is a special situation which demands that I should speak. In that case, if I am silent, then silence is what? Then silence is fraud. So this generally doesn't happen in all the cases, but in case of insurance, in case of sale of immovable property or any contract relating to immovable property, in case of issue of prospectus, in case of any family agreements, and finally in case of marriage. In these 5 contracts, even if the other person does not ask me anything, I'm still liable to tell everything, right? Even if this other person does not ask me anything, even if the other person does not ask me anything, I'm still liable to say, right? I'm still liable to disclose it. So in that case, if I'm silent, then silence is what? Then silence is considered as fraud. So where it is the duty of the person keeping silent to speak, right? And the second, when silence equals to speech. When my silence is equivalent to speech, then silence is fraud. If you don't deny, I will deem that this painting is made by Picasso. I keep quiet. I have agreed that it's made by Picasso. Right? Is it clear to all of you? So I repeat again, there are 5 categories of fraud. Making a wrong statement, not saying something that we should say, contract made without an intention to perform, any act declared fraudulent by law, any act which is done to deceive, any act fitted to deceive. Any act fitted to deceive. Now, when we say fraud, silence is not considered as fraud. However, silence is fraud in 2 cases. When it is the duty of the person keeping silent to speak and when silence equals to speech. Right? I hope this is clear to everyone. Now, what is misrepresentation? What is misrepresentation? Assertion of the fact which is not true though he believes it to be true. Right? Assertion of the fact which is not true though he believes it to be true. I have made a statement which is not true but I believe it is true. I have made a statement which I believe it's true but it's not true, right? That means I have not done it intentionally, it is done unintentionally. Breach of duty without an intention to deceive. Gains an advantage over the other by misguiding and making a wrong statement. By making a wrong statement, I am gaining some advantage, making a contract. Like for example, I say the painting is made by Picasso. I thought the painting is made by Picasso and I say the painting is made by Picasso. It was actually not made by Picasso. But I thought it's made by Picasso. And because of this, I'm gaining this contract, I'm gaining the consideration. But it was not done with an intention to deceive. It was without an intention to deceive. Causing innocently a party to make a mistake as to the fact of the contract. The parties are making a mistake, but that is not done intentionally, it is innocent. This is considered as what? Misrepresentation. I hope it's clear. Now, when we talk about coercion, undue influence, fraud or misrepresentation, what are the consequences of the four? The contract is voidable. The contract is what? Voidable. That means the aggrieved party can either cancel the contract or affirm the contract. Right? The aggrieved party can either cancel the contract or affirm the contract. If he cancels, fine, it becomes void. If he affirms, it becomes valid. Now, where one party uses fraud or misrepresentation, but the other party, if he would have used his diligence, right? Who used his diligence would have come to know the facts. The contract is valid. That means I am trying to defraud you, but you had means to discover the fraud. So here even your diligence is lacking, even you are negligent. So when you are negligent, you cannot claim any relief. The contract is what? The contract is valid. Again, if one party is using fraud or misrepresentation but the other is not misled. See, the whole concept is fraud is not fraud unless it misleads you. Fraud is not fraud unless it induces you to contract. Right? Fraud is not fraud unless it induces you to contract. My fraud should induce you to contract, only then it is considered as fraud. So if it does not induce you to contract, it is not considered as fraud and the contract is a normal valid contract. I hope it's clear to everyone. Now what is mistake? Mistake is a wrong belief, an erroneous belief, a wrong belief. I know something wrong. I mean, a bill or are we either both the parties or any one of the parties having some wrong belief about the contract. So that is what? That is mistake. And to put it in simple terms, error. Right? To put it in simple terms, an error. Now, when we say mistake of fact, fact means what? Fact means the essential facts of the contract, right? The essential facts of the contract. Now, when we say essential facts, that means what? That means I'm talking about yes, you can say that, Badrul, correct. Innocent belief, correct. So, fact means what? The essential facts of the contract, right? Fact means what? The essential facts of the contract. What kind of a mistake can I have about the essential facts? The existence, the quantity, the quality, the identity, anything about the subject matter. But when it is a mistake of price, price is not considered as the essential fact. Bilateral mistake. What happens? The contract is void. What is bilateral mistake? When both the parties are mistaken about the facts of the contract. Right? What is bilateral mistake? When both the parties are mistaken about the facts of the contract. We call it as a bilateral mistake. And in case of bilateral mistake, the contract is void. But if it is a bilateral mistake of price, if it is a bilateral mistake of price, the contract is absolutely valid, right? The contract is absolutely valid. Now, what is unilateral mistake? Unilateral mistake means one-sided, that is mistake of one party. In case of unilateral mistake, the contract remains absolutely valid. Then, again, mistake could be of law also. See, for everything we do, there is a law. I've told you, even when you walk on the road, there is a law. And it is your duty to know the laws of your country. It is your duty to know the laws of your country. Ignorantia juris non excusat. Ignorantia, ignorance, juris, law of land, non excusat, not an excuse. Ignorance of the law of land is no excuse and the contract is absolutely valid. But when we talk about mistake of foreign law, see, I need to know the laws of my country. If I'm supposed to know the laws of every country, gone. My life will be gone in only knowing laws. So if it is a mistake of foreign law is what? Mistake of fact. And the contract is correct. Now, if you have any doubts in this, tell me. Then otherwise, we'll move to the next one. You want me to explain mistake of fact again? Fact means the subject matter of the contract. Okay. Fact means the subject matter of the contract. Let us say A wants to sell his horse to B and B agrees to purchase, right? A wants to sell his horse to B, B agrees to purchase. Both A and B do not know horse is dead. First of all, here, what is the contract made for? What is the contract made for? It is made for the horse. The horse is the subject matter. Here, both A and B do not know that the horse is dead. Right? Here, both A and B do not know that the horse is dead. Correct? Both A and B do not know that the horse is dead. Can we say it's a mistake about the fact? The contract is made for the horse. The horse is the essential factor of the contract. Here, both of them are mistaken about the horse. So, it's an essential factor of the contract. The contract is what? The contract. I hope it's clear. Yes, the contract is what? The contract is what? On the other hand, on the other hand, A has a jewelry store, right? A has a jewelry store and B enters the jewelry store. He sees a necklace and he believes it is made of real diamonds. He purchases that necklace. Later he comes to know it's not real diamonds. Can he return it? Yes, Lekhna, that was a bilateral mistake. A has a horse which he wants to sell to B. Sorry, I'm so sorry. A has a jewelry store. B goes to the jewelry store to purchase some jewelry. He saw a necklace and he believed it's made of real diamonds. He purchased it. Later he comes to know it's not real diamonds. Can he return it back? Come on, everyone is supposed to answer. Can he return it back? Exactly, no. Unilateral mistake. The contract is absolutely valid. You can see, you can think, you can believe whatever you like. How does it affect me at all, right? How does your thought actually affect me? Is it clear? Can we move to the next part? Now, before I go to the next part, I'm just giving you 2 minutes. I want you to go through. I mean, if you have any doubt, you ask me. Otherwise, we'll go to the next part. Now, moving on to the next one. So, Kaushik, if you lie, it's fraud, isn't it? Hello, done. Now, moving on to the next one. Unlawful object. Object, I already told you, it is fraud, Rikta. Your horse is dead, but you're still telling the other person, I want to sell you my horse. Knowingly. This is what? Fraud, right? Sorry, Badrul, I did not get you what you have written. Now, unlawful object. Object means the purpose for which the contract is made. This purpose should be what? Lawful. If it is unlawful, the contract is void. Now, how do we understand what is unlawful, right? How do you understand what is unlawful? For that, we have to understand what is lawful, the rest everything is automatically unlawful, right? So, first of all, if it defeats the law, see, for everything there is a law. If you go against the law, it's automatically what? It's automatically void, right? I repeat everything, for everything there is a law. And if you go against this law, it is what? It is void. For everything there is a law, it is your duty to follow the law. You go against the law, it's void. If it defeats the provisions of the law, Hindu law, Muslim law, even if you go against these laws also, they are void. If it defeats the rules of the law, when I use the word rule, law includes act, rules, provisions, act, rules, regulations, ordinance, bylaws, and orders. So even rule is a part of law. Even though rules are subordinate to the act, but still they are a part of law, right? Still they are a part of law, and it is our duty. It is our duty to follow these laws. And if we fail to follow these laws, obviously it is what? It is not valid. So even if you go against the rules also, that is also unlawful and hence it is void, right? Fraudulent, where the agent acts outside his authority. And the third party knows that he is acting outside his authority. I have zoomed it so much already. Dhanush, I have already zoomed it so much. And if it's not visible, because I did not know there would be a problem with this color. Because of the color, it's not visible. Please keep your notes. Whenever you are doing a revision class, your notes should be there in front of you. Whenever you are attending a revision class, it is so mandatory that you should have your notes in front of you, isn't it? Right? So, please keep your notes in front of you. I have already zoomed it out a lot. It's just because of the color that some problem is there, that this is the way it is. Right? So, the agent acts outside his authority, fraudulent. If an agreement causes injury to a person or his property. So these are revision notes for you all. So the reason the fonts are small or it's done in chart way, the reason is because if I give you long lengthy answers again, so that will be equivalent to your notes only, no? So you have to read again 10 pages like that. That has been concised into one page. That is why it is small, and that is the reason the font or everything is so small. So that you can just go through that one page and it covers up entirely the whole topic. Okay, no problem, Dhanush. I'll still zoom it out. If any agreement causes injury to a person or his property, remember I wanted to change my profession and you people had given me some lovely ideas. But being a Marwari, I decided to do business. So I asked you to steal someone's patent, someone's trademark, someone's copyright, right? So I'm causing injury to a person's property by asking you to steal their patent, trademark, or copyright. It is against law and hence it is what? Hence it is void. Any agreement which is immoral, see, there are social laws. Morality basically relates to the social laws. If I enter into any contract which goes against these social laws, such a contract is what? It is immoral. And finally, against public policy. See, public policies are made for the public. Being a part of the public, it is my duty to follow these policies. If I enter into any agreement which is against these policies, it's what? It is void. Right? If I enter into any agreement which is against these policies, it is what? It is void. Now, what is agreement against public policy? We have 10 heads which falls under agreements against public policy. So what are these 10 heads? The first one, trading with enemy. The first one, trading with enemy. Trading with enemy. If my country is at war with another country, right? If my country is at war, so let's say this is country 1 and this is country 2. Inhabitant of country 1 enters into a contract with inhabitant of country 2. But there was already a war going on. You are indirectly funding your enemy only. It's against law and hence it is void. Clear? It's against law and hence it is void. Stifling means to suppress. Prosecution means an offense should be punished. See, for some offences, punishment by way of imprisonment is mandatory, whereas for some other offences, imprisonment is not mandatory. If you have committed an offence where imprisonment is mandatory, but the parties settle, that is the instead of imprisonment, we just settle it with a fine. That is what? That is void, right? So we have settled it with a fine instead of imprisonment. The person should have been imprisoned. It is what? It is void. Champerty and maintenance. In both champerty and maintenance, one party is helping the other party to sue a third party, right? In both champerty and maintenance, one party is helping the other party to sue a third party. Now, whenever a suit is filed, there will be some result of the case. When I share this result with you, with the other party, it is champerty. When I don't share the result with the other party, it is maintenance. I repeat again, I am helping you to sue a third party. Now, obviously, when a case is filed, you will either win the case or lose the case. If you win the case, you will get something out of that case. When we both share that result, it is champerty. When we both don't share the result, it is what? It is maintenance. So, champerty and maintenance, one party helps the other to file a litigation and shares the resultant interest, champerty. Do not share the resultant interest, maintenance. Generally, champerty and maintenance is void, but if it is in good faith, that is without an intention to cheat or harm another person, it is absolutely valid. Correct? Now, interference with the course of justice. Interference with the course of justice. What is course? The path the court takes to give a verdict. When we say course of justice, it is on the basis of the evidences and the witnesses provided that the court comes to a decision. I repeat again, it is on the basis of the evidences and the witnesses that the court comes to a decision. Now, when the court comes to a decision on these bases, but we tamper with these only, it is interference with the course of justice. So, bribing the witness of any case or tampering with the evidences is considered as interference with the course of justice. Then, sale of public offices. You bribe. You bribe. Why you bribe? For a public post or for a public title or trafficking in public offices. It is what? Sale of public offices. But you know what? Bribing can be done for other reasons also. When you are bribing, I repeat again, when you are bribing for public offices, it is sale of public offices. But I want a favor from you. And to get that favor from you, I bribe you. So there could be bribing for other reasons also. So I want a favor from you. I repeat again, I want a favor from you, and for that I pay you. Right? So this is also bribing. This is interest against obligation. When I bribe, I want a job in the income tax department, I bribe for that. This is sale of public offices. I want to get a tender and I pay someone money to disclose all the quotations so that I can quote the lowest so that I win the tender. This is what? Interest against obligation. Till this point, okay? Till point number 6, that is 1, 2, 3, 4, 5 and 6. Okay. Till point number 6, whatever we have done, all of them are illegal also. Okay. The rest are all just void. What is the next one? Marriage brokerage contract. What happened, Dhanush? What happened? Marriage brokerage contract. I'll get a husband for you or I'll get a wife for you in exchange of money. Right? I'll get a husband for you or I'll get a wife for you in exchange of money. This is what? Marriage brokerage contract, right? This is what? This is marriage brokerage contract. I'll get a husband or wife for another. No. I'm not rendering my services here. So don't say, ma'am, you said no, you will get. So it is void. Now, when I say void, that means if I find a spouse for you, but you don't pay me, I cannot sue you. You pay me, but I don't find a spouse for you. You cannot sue me to recover the money, right? Because you're selling public offices. Bribing for jobs is selling, no? Oh, okay. Restraint of agreement and restraint of marriage. A person is getting married. You say, I'll give you rupees, don't, I'll give you money, don't get married. अरे भाई उसकी मर्जी, he wants to get married, उसकी मर्जी. Who are you to interfere? Let them get married, no? Right? Let them get married. What is your problem? What is your problem? So, agreement and restraint of marriage. Then agreement and restraint of trade or for the creation of monopoly. See, every person has a right to carry a lawful trade. Any agreement which stops the competition in the market, any agreement which stops the competition in the market, that is any agreement which is anti-competitive, or any agreement which stops a person from carrying a reasonable trade is against public policy and hence it is void. Agreement in restraint of trade. Every person has a right to carry a business. If the restraint is reasonable, it's valid, but if it is unreasonable, it is void. Any agreement which is anti-competitive is considered as against public policy under the Competition Act and hence it is void. Then the last one, agreement and restraint of legal proceedings. That is, two parties. It's a valid contract. So A has a right to sue B, B has a right to sue A, right? Two parties have entered into a contract. So A has a right to sue B, B has a right to sue A. If the agreement stops them from suing, such an agreement is void. If the agreement says that we cannot sue each other, such an agreement is void. But if they have agreed that if there is a dispute, we will go to the arbitrator, right? If they have agreed that if there is a dispute, we will go to the arbitrator, or they had a dispute, and while settling this dispute, they made a written agreement that for future disputes, they would go to the arbitrator, right? In this case, if one party stops the other from going to the court, it's absolutely valid. Otherwise, every person has a right to go to the court and no one can stop. Clear, all of you? Yes, we are done with this unit. And there is one more, agreement expressly declared void. It's not given here, so I'll just discuss that. Agreement expressly declared void. We have three cases here. The first one is agreement, the meaning of which is uncertain. A says to B, I'll sell you 100 liters of oil at rupees 50 per liter. B agrees. Is it valid? Even if B agrees, since the oil has not been mentioned, right? The oil has not been mentioned. Since the oil has not been mentioned, it is what? It is void. Correct? It is what? It is void. Right? So agreement, the meaning of which is uncertain. Then agreement which has two parts, one legal and other illegal. So if the agreement consists of two parts, one legal, the other illegal. Now here we have two situations. First, if the contract is separable. If it is separable, the legal part is valid, the illegal part is void. But if the parts are not separable, that is, if I can bifurcate the legal and illegal part, if I can divide the legal and illegal part, if I can say this is for legal, this is for illegal, then legal is valid, illegal is void. But if I cannot say this is for legal, this is for illegal, or I cannot bifurcate, then the contract is completely void. Right? Yes, Kaushik. Wager. What is wager? Betting, game of chance. A says to B, I'll give you rupees 100 if it rains. You give me 100 if it does not rain. This is what? Wager. I'll give you 1 lakh if India wins the match. You give me 1 lakh if India does not win the match. What? Wager. An agreement to give money or money's worth on the happening or non happening of a future uncertain event. Can I say the event rain is the sole factor of this agreement? Sole determining factor, yes, because it is this event rain which is going to determine the outcome. It is this event rain which is going to determine the outcome of the contract. In India, wagers are void, but in the state of Gujarat and Maharashtra, it is also illegal. Right? In India, wagers are void, but in Gujarat and Maharashtra, they are also illegal. Correct? Now, with this, we are done with this unit. Before I move to the next unit, I am giving you, because till now it was huge, it was, the essentials. I'm giving you 5 minutes. I'm here. I'll wait. If you have any doubts, you ask me. Otherwise, we'll move to the next set of discussion. Yes, Sandhya, for non-separable, it is void ab initio. Kaushik, just because I did not say void ab initio doesn't mean it's not void ab initio. I already told you that other than supervening impossibility, contingent contract, everything. Sandhya, uh, did you understand that I answered your question? Did you understand that? If it is not separable, it is completely void. Yeah, sure, I'll explain. So, what exactly is a speculation or a speculative transaction? Speculation is basically a future trading. Speculation basically is future trading. I am going to trade on a future date, hoping to earn profits or to protect myself from losses, right? Hoping to earn profits or to protect myself from losses. So, when we say speculation, okay, so A and B have agreed that A would sell B goods, to B, but not at today's price, at the price on the day of delivery. So, we are not going to deal with the price today. We are going to deal with the goods at the price which is prevailing on the day of the delivery, like in gold jewelry. We generally don't pay the price on the day of the making, we pay the price the day we purchase the gold, right? So, on the day of the, the delivery. Now, on the day of delivery, the price goes up. It's a profit for the seller because he'll get more price for each good. On the other hand, if it goes down, it's a loss for the seller because he's going to get lesser. So this is what we mean by speculation. Okay? This is what we mean by speculation. And this is absolutely valid. But let us say the price of gold today, I'm just taking a hypothetical case. Let's say the price of gold today is 50,000. A and B are speculating. A says the price will go up to 65,000. B says no, 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 it will go down to 30,000. They are speculating. No, no, he says no, 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 65, 30, 65, 30. They start fighting, right? B says in your dream also, no, it will never go to 60,000. A says you die and come back also, it will never go to 30,000. They keep fighting, 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 fighting. Finally, A says, okay, let's do one thing. If the price goes up to 65,000, you pay me 15,000. If the price goes down to 30,000, I will pay you 20,000. A says to B, if the price goes up to 65,000, you pay me 15,000. If the price goes down to 30,000, I'll give you 20,000. Can we say this is a wager? And it is what? It is what? Yeah. What happened, Nikita? A full hee ha 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 moment. Chalo. Can we move to the next topic? Do you have any doubts here? Do you have any doubts here? Well, I guess no. We'll move to the next topic. I got that. You're kind of predicting. Kaushik, you're kind of predicting. Chalo. Now moving on to the next unit. This unit talks about everything relating to performance of the contract, and then it talks about discharge of the contract. So first of all, before I go into the succession and assignment, tell me which topic, Nikita? Which topic are you saying, Nikita? So who can perform the contract? They will not tell you write all. And even if you forget one, two, it's okay. I mean, even if it is for 7 marks, you write 7 points, that's more than it. Okay? Tell me who can perform like minors agreement. Guys, listen. Can you get a question like what are the rules of minors agreement? Yes. So let's say you get it for 7 marks. Are you supposed to write all the 14 points? No. First, write the main points and then add any the other points also. Even if you write 8, 9 points, it's more than enough. You don't have to write all the 14 points. Got it? So tell me who can perform the contract. This answer I want from you. I've been talking, 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 talking. Since then. No, Dhanush. Questions are from 2 to 7 marks. No, you don't have to write all. Give me the answer. Who can perform the contract? Exactly. The promiser can perform the contract. Okay, agent. So first of all, the promiser can perform the contract, right? Okay. I see so many people are there online. But how many of you answering? Oh my god. Super number. Super number are answering, huh? Okay. So who can perform? Promiser can perform. Apart from the promiser, can the agent also perform? Yes, the agent can also perform. Apart from the agent, can the legal heirs, in case of death, can the legal heirs perform? Yes, the legal heirs can perform. But when the contract is of, right? When the contract is of personal skill and confidence, right? When the contract is of personal skill and confidence, who knows? He can have a battalion or a cricket team also. Who knows, right? When the contract is of personal skill and confidence, only the parties can perform. Correct or not? Thank you, Purvi. Even a third party can perform. Yes. And finally, can we also say that joint promisers can perform? Yes. So any one of them can perform the contract, correct? Correct? Yes. So let us say when you ask a painter to paint a picture for you and before the painting is complete is swaha, can his legal heirs and say, sir, मैं हूँ ना sir, sir, मैं हूँ ना sir, मैं आपकी painting बनाऊंगा. He can say anything he wants, but the point is, do I want it? No, no. Okay. Chalo, moving on to the next one now. Succession and assignment. What is succession and what is assignment? Succession means when a person is dead, his property is transferred to his legal heirs, right? When a person is dead, his property is transferred to his legal heirs. It happens by the operation of law, right? It happens by the operation of law. What is assignment? Assignment means transfer of what? Rights. Assignment means what? Transfer of rights. Assignment takes place either by operation of law or by agreement. So when a person is swaha, automatically property and everything will go to his legal heirs. This is what? This is succession. Operation of law means by the effect of law. Whereas A has to pay B 10,000 and he says, don't pay me, pay to C. This is what? This is what? This is assignment and this is happening by agreement. Okay. So I repeat again. Succession means inheritance which takes place by operation of law. Assignment means transfer of rights which takes place either by agreement or by operation of law. Now, when I say succession, I give the legal heirs the assets. Do I ask them, oh legal heir, will you take liability or should I keep? Papa, you're getting assets. No, you bear liability. Simple, right? So, both assets and liabilities are transferred, but liability to the value of assets. So that means he inherited 10 lakh of asset, 8 lakh of liability. He will pay 8 lakh of liability and then the remaining 2 lakh will be his. On the other hand, if he inherited 10 lakh of assets and 15 lakh of liability, right? 15 lakh of liability, is he personally liable to give that 5 lakh rupees? No. He will only pay 10 lakh proportionately and the rest 5 lakh respectively will be a bad debt in that other person's, whoever it is, creditors accounts, right? Now when we talk about assignment, A had to pay B 10,000. A says I will not pay, C will pay. So, what is the basic difference between the two cases? What is the basic difference between the two cases? In the first case, it is the right which is transferred. In the second case, which is the liability which is transferred. Okay? This is valid. Now B says, I don't want the money. Now B says, just give me a second. Now B says, I don't want the money from C. I don't trust this guy. You give me or I don't want it. Either you give me or I don't want it. So, is the assignment of liability valid? No. Liability can be assigned only when all the parties agree. So, I repeat it again. Succession is inheritance. Assignment is transfer of rights. Succession takes place by operation of law. Assignment takes place either by agreement or operation of law. In succession, both assets and liabilities are transferred, but liability to the extent of assets. In assignment, liability can be transferred only when all the parties agree to it. Okay. Now, effect of refusal to perform. What is this effect of refusal to perform? Let us say one party is ready and willing to perform, but the other refuses to accept. The party which is ready to perform shall have no obligation to perform again, but has a right to claim the damages. So, when A is ready and willing to perform, but B refuses to accept, so A has no obligation to perform but has a right to claim damages. Right? A has no obligation to perform but has a right to claim the damages. Can we call B the breaching party and A the aggrieved party? Right? B is the breaching party and A is the aggrieved party. Time and place of performance. I think joint promises is not given. I'll just discuss the joint promisers cases. Again, joint promiser is like, it's one of the favorite, what do you say, parts of a quest, the topic, favorite topic of the institute. Some, every alternative terms are here and there, they'll keep giving it. So what exactly is a joint promiser? ABC jointly promised to pay the 6,000. So ABC are joint promisers. Now what is the liability of the joint promiser? Now what is the liability of the joint promisers? Each of them is liable for their own share, right? Each of them is liable for their own share. So let's say if given the ratio is 3:1, they will be liable for 3,000, 2,000, 1,000, right? But if nothing is given, then the ratio is equal. So each of them is liable for 2,000 each. After making the promise, B and C run away, right? After making the promise, B and C run away. So when B and C run away, can we say liable for the whole of the 6,000? Yes. They are jointly liable for their share and severely liable for the whole share. Right? And severely liable for the whole share. Now let us say A pays off the money. So when A pays off the money, what will happen here? Can we say B and C are liable to give their share to A? Each of them is liable to pay 2000 each, correct or not? Yes. So each of them is liable to pay their share to A. So if one of them pays on behalf of the others, he can recover from the others their respective share. Now let us say if C is unable to pay, he is not able to pay anything. Why is he unable to pay? He's become insolvent, right? Why is he unable to pay? Because let's say he's become insolvent, right? So his loss in that case shall be borne by the other two, that is 3000 each. On the other hand, if let's say C pays off 1000, right? If C pays off 1000, so what is the liability of each of them? 2500 each, right? Correct? Now, if A is dead, what happens then? If A is dead, what will happen then? His legal heirs along with B and C will perform, right? If all the four are dead, then the legal heirs of all the four will perform, correct? I did not understand, Siddharth. What are you asking? Like, what did you ask me, Siddharth, about it? I did not understand. Yes, if all the four are dead, then the legal heirs of all the four are responsible, correct? Clear? Now, if D releases A, that is, he says that A doesn't have to pay. Okay? Now, A doesn't have to pay means I'm not saying you pay me 4000 only. No, you still pay me 6000, but A is not responsible. Then tell me, Kaushik, that was the second thing that I explained. If one of them pays on behalf of the others, he can recover from the others their respective shares. Tell me, if D releases A, are B and C liable to D? Okay? I'm going to write two questions. You have to answer this. And is A liable to B and C? Read it and give the answer. Okay, jaldi se tell me the answer. Okay. What is meant by discharge of liability? Discharge of liability means you don't have to pay me. Release means you don't have to pay me. You are not liable. So, in this case, even if D releases A, okay, even if D releases A, B and C are still liable to D. Yes. And A is still liable to B and C. A is still liable to B and C. A is still liable to... Ma'am, why is A liable? Ma'am, this is not correct. No, see, there are two contracts. One is ABC, one is ABC and D. Right? One is ABC, one is ABC and D. Now, the contract D is releasing A is this. But between the contract of A, B and C, A is still liable. Correct? Now, time and place of performance. If no time is given, the contract has to be performed within a reasonable time. If day is given but no time is given, it should be during what? Business hours. Then again, no place is fixed. It is the duty of the promiser to ask the promisee to fix a reasonable place. And last, I will perform on a specified day, but I will perform only when you ask me to perform. I tell you, next week I'll take a revision class again for you all. But come to the class only when I tell you. If I don't tell you, why will you come to the class, right? Promiser has to, like performance is on a particular day. Promiser has to perform on a particular day, but he will perform only when the promisee asks him to perform. So it is the duty of the promisee to ask the promiser to perform the contract, right? So performance is on a particular day, but promiser will not perform unless asked by the promisee. It is the duty of the promiser to ask the promisee. Oh, sorry, this is wrong here. It is the duty of the promisee to ask the promiser to perform the contract, correct? Now, time of performance. See, generally in every contract, time for the performance is given, right? Right? Generally in every contract, time for performance is given. In some cases, time is of essence, whereas in some other cases, time is not of essence. Of essence means if we fail to perform within the time, the aggrieved party will suffer losses. In this case, the contract becomes voidable. Now, when I say contract becomes voidable, if you cancel the contract, you can also claim the damages. On the other hand, if you affirm the contract, can you still claim the damages? Yes, you can claim the damages if it is mentioned. If it is mentioned, right? Now, if in the contract time is not of essence, right? The contract is valid, but you can claim the damage. For example, time of delivery in sale of goods and time of payment in sale of goods. Time of delivery is of essence, whereas payment is not of essence. So, if it has been given that I will deliver the goods on this day and I don't get the delivery on that day, I have a right to reject the goods. But payment is supposed to be made today. If I get the payment after 10 days also, I can accept it. I mean, I have to accept it unless given it is of essence. But for the delayed payment, I will get the interest for the delayed payment, which becomes the damages. Correct? Now, appropriation of payment. What is appropriation of payment? Appropriation of payment means adjustment of payment. What is appropriation of payment? Adjustment of payment. What does this mean? Can I take more than one debt from the same debtor? Yes. I am so sorry. Can I take more than one debt from the same creditor? Yes, I can. I totally can. Is it mandatory that I have to pay the whole amount in one go? No. Can I just make a part payment? Yes. So when I have several debts and I just make a part payment against which debt we adjust this payment is known as appropriation of payment. Right? When I have several debts against and I make a part payment against which debt I adjust this payment is known as appropriation of payment. First of all, who is making the payment? The debtor, right? Now, ma'am, many of you would be wondering, ma'am, why do I have to show it separately? Composite amount, yes, but remember, The date of payment can differ, the rate of interest can differ. One debt may become time barred before the other. It could be anything. So it's important that we show it separately. Correct? So when I have several distinct debts and I make a part payment, against which debt we adjust this payment is basically what we are going to discuss here in appropriation of payment. Now, first of all, who is making the payment? The debtor. So the debtor shall specify which debt to set off. So when the debtor makes the payment and he says that set off this debt, can I set off any other debt? No. He says set off this debt, can I set off any other debt? No. He says set off this debt, can I set off any other debt? No. So when the debtor makes the payment, he can specify which debt has to be set off. And if he specifies that this debt should be set off, then and if the creditor accepts the payment, the creditor cannot set off any debt other than that debt. So when the debtor makes the payment, he may specify which debt to set off. So the first right to specify is with the debtor, right? And if the creditor accepts, he must set off that debt only, right? Now, if the debtor makes the payment on account generally, what is on account generally? On account generally means without specifying anything. On account generally means without specifying anything. I just give a composite amount against my payment. I just give a composite amount against my payment without specifying anything. So, if the debtor makes the payment on account generally, then who is receiving the payment? The creditor. So, creditor can set off any debt, right? Kaushik, obviously. So, if the debtor does not specify anything, the creditor can set off any debt. Can he also set off a time barred debt? Can he also set off a time barred debt? Huh? Yes. Can he set off a time barred debt? Yes, he can set off a time barred debt. Can he set off a disputed debt? Can he set off a disputed debt? Can he set off a disputed debt? Sometimes I look at this screen, sometimes I look on at my phone. I have two chat boxes here. Can he set off a disputed debt? No. No. Unless the dispute is settled, how can you set off that debt? Unless the dispute is settled, how can you set off that debt? So he can set off any debt, including a time barred debt, but he cannot set off a disputed debt, right? He cannot set off a disputed debt. What is disputed debt? We are disagreeing on some debt. The amount, the time of repayment, the interest, any dispute is a disputed debt. Is it clear? But if nothing is specified, okay, if nothing is specified, then what happens? If nothing is specified, then first in, first out. The debt first in order of time will be set off first. First debt in order of time. Right? First debt in order of time. Now, if there are more than one debt on the same day and it is not sufficient to pay the whole amount, then it will be set off in their what? Proportion. Right? Be set off in their proportion. Is it clear, all of you? Chalo. The next topic, reciprocal promises. What is reciprocal promises? Dependent. What is dependent promises? Performance of one depends upon the performance of the other. Right? What is dependent promises? Performance of in their ratio. In their ratio, that is what in their sense. So reciprocal promises means what? Dependent promises. That is performance of one depends upon the performance of the other. Right? So let's say A says to B, let's say A says to B, I will deliver you the goods after 10 days and you pay me after 15 days. Is this reciprocal promises? A says I will deliver after 10 days, B says I will pay after 15 days. Is it reciprocal promises? Why no Varun? Why no Purvi? Why no Dhanush? Upendra? Oh my god, everyone is saying no. They are not dependent. Where is the dependency? They are not dependent. For reciprocal promises, the promises have to be dependent. They are not dependent, they are two independent promises. I will deliver, you will pay. After 10 days, after 15 days. But neither performance is dependent on the other. So they are not reciprocal. Exactly. But if it was, I will deliver only when you pay, then can I say it is dependent? I will deliver only when you pay. Then can we say, yeah, absolutely. No, Teju. Modification of offer is nothing at all. Modification of offer is nothing. It's counter offer. I saw Dhanush. I said, if it is dependent, then it's reciprocal. I will pay after 15 days after delivery, then it's reciprocal. Now, how do we fix? Now, we understood reciprocal promises are dependent promises. And when we say dependent, it means what? Performance of one depends on performance of other. Dhanush, this is not dependent. Dhanush, this is not dependent. Here it doesn't say I will pay after 15 days of delivery. No. Here are two independent promises. A will deliver after 10 days, B will pay after 15 days. Two independent promises, not dependent on each other. Got my point, Dhanush? It doesn't say I will deliver 10 days after you pay. No. Or it doesn't say I'll pay after 10 days of delivery. No. They are two independent promises. Okay? So, performance of one depends upon the performance of another. That means one will perform and then the other will perform. Am I right? Right? One will perform and then the other will perform. Correct? Now when I say one will perform and then the other will perform, who decides which one will perform first and which one will perform later? I just said dependent on performance of one depends upon the performance of the other. That is one will perform after the other will perform. But the question is, Who will decide who will perform first and who will perform later? How do we fix? Can we say the parties may themselves fix the order? A says you perform first, then I will perform, or A says I'll perform first and then you perform and B agrees, or vice versa. Can we say it can be fixed like this? Yes. So by the parties means the parties fix the order, right? Parties fix the order. Now the question is, if the parties have fixed the order, performance should be in this order or in a different order. When the parties have fixed the order, performance should be in this order or in a different order. It should be in the order fixed and not otherwise. Performance must be in the order fixed and not otherwise. Correct? Now, it may also be fixed by implication, right? It may also be fixed by implication. What is implication? Deemed from the contract the order of performance. Deemed from the contract the order of performance, right? I will sell you goods worth 40,000, but you have to give me a security deposit of 5,000. Now, I did not say that unless you give me the security deposit of 5,000, I will not give you the goods. But isn't it obvious that unless you give me security deposit, I'll not give you the goods? So it is what? It is implied. Implied from the situation, the order of performance, right? Now, in case of reciprocal promises, if one party prevents the other from performing, A wants to build a house on the hilltop, hires B to build the house, to construct the house. But timber will be supplied by A. Can we say this is reciprocal promises? Can we say this is reciprocal promises? Wow, Puri. Can we say this is reciprocal promise? Unless A delivers the timber, how will B build the house? Yes or no? Yes, A does not deliver the timber. A does not deliver the timber or the material. So tell me, is B under any obligation to perform again? Is B under any obligation to perform again? No. Does B have any rights? Yes. What? B can claim the damage. Correct? Restitution. Restore. Restore means to pay back. Restore means to pay back. Right? Restore means what? Restore means to pay back. When a contract is voidable, okay? Right? When a contract is voidable and the contract is cancelled, or when a contract becomes void. When a contract is voidable and the contract is cancelled, or when the contract becomes void, whatever benefits have been received have to be returned back. So, for example, you took advance for a contract and the contract becomes void. You have to return back whatever advance you have received, right? You have to return back whatever advance you have received. This is what? Restitution. You were cheated for the color of the shirt. Later, you return the shirt back. So, whatever you have received, the price of the shirt, you have to return it back. Is it clear? Now, before we go to the next part, we are done with all the things relating to performance of the contract. Before I go to the discharge of the contract, giving you 2 minutes, go through. You have any doubts, you ask me, and then we will go to the. Yes, yes, I'll explain it. So I'll just explain restitution once more. Uh, let's say you remember I had discussed this yo-yo's example with you all. He wanted to take a theater on rent, okay? So he paid the advance money for booking. Not the whole money, advance money for booking. But the theater is swaha before the show, right? The theater is swaha before the show. Now, can we say that he can ask for the refund of the advance money? Can we say he can ask for the refund of the advance money? Yes or no? Can we say he can ask for the refund of the advance money? No. Can he ask for the refund of this advance money from the owner of the theater or not? So this refund is restitution. Okay? Did you understand? So whenever a contract is voidable and the contract is cancelled, or if the contract becomes void on a future date, so whatever benefits we have received, those benefits have to be refunded or returned back. This is known as restitution, right? These benefits have to be refunded or returned back. This is known as restitution. Clear? Chalo, now can I go to the next topic? Yes, discharge of the contract. What is discharge of the contract? Termination of the contract, right? What is discharge of the contract? Termination of the contract. That is, contract comes to an end. The contract is over. Okay. Varun also, I hope it's clear. That is, contract is over. The contract comes to an end. The contract is over. Contract can be discharged by performance, which can be actual or attempted, or by lapse of time or operation of law, or by mutual consent, which is novation, rescission, alteration, or remission, then by impossibility of performance, which can be existing at the time of contract or supervening impossibility. Correct? Now, what is by performance, actual or attempted? What is actual? Parties have performed. A had to deliver goods, B had to pay the price, A has already delivered, B has already paid. Right? Contract is done. This is what? Actual performance. A had to deliver goods to B, B had to pay the price. A is ready to deliver but B refuses to accept. By A's attempted performance, the contract is discharged. Good, Purvi, good. Lapse of time. Yes, we can also call it as executed contract. Lapse of time, the best example, time barred debt. Operation of law, mergers, insolvency, death, In all of these cases, the contract is discharged, right? What is this merger? Let us say A agreed to to give his land on lease to B for 5 years. But after 3 years, he sold the same land to B. Two different contracts, same land, same parties. Can two different contracts run? No. So which one will discharge? Lease will merge into sale and lease will discharge. Correct? Then by mutual consent, novation, we cancel the old contract and a new contract is made between the parties in place of the old one. This can happen either between the same parties or with a new party. What is rescission? We cancel the contract. So in both rescission and novation, one part is similar. In both the cases, the old contract is cancelled. When in place of the old contract, we make a new contract, it is what we call it as novation. When we don't make a new contract, it's alteration. Alteration means change in the terms of the contract. Here, the contract is not cancelled. The contract remains, just the terms of the contract are changed. Then remission. What is remission? Remission means acceptance of a lesser amount in full and final settlement or acceptance of kind in place of cash. Right? Then by impossibility of performance existing, so we'll just mark it. So actual performance, the parties fulfill their obligations under the contract. Attempted, one party performs but the other refuses to accept. Lapse of time, time barred debt, operation of law, death, insolvency, mergers, I already told you. Novation, new contract for the old one. Rescission, cancellation of the old contract. Alteration, change in the terms of the contract. Remission, payment of less amount or payment in kind. Now, impossibility of performance. Existing at the time of entering into the contract. Known to both. Remember, Tare Zameen Par. Unknown to both, if you remember the horse dead. Right? If you remember the horse dead. Known to one. Again, someone had asked me this question, ma'am, what if he knows his horse is dead, still he makes a contract to sell the horse? Obviously, it is fraud. Obviously, it is fraud. And because it is fraud, you also have to give damages. Right? Because it is also fraud, you have to give damages. Now, what is supervening impossibility? Post contractual impossibility. What is post contractual impossibility? That is, after the contract is made, it becomes impossible to perform. Right? After the contract is made, it becomes impossible to perform. When the contract was made, it was valid, but before the contract could be performed, changes take place which makes the performance impossible, making the contract void. It should have been voidable, but because it is impossible to perform, it should have been voidable, but because it is impossible to perform, it cannot be voidable because I can never make it valid. It can never be voidable because I can never make it valid. So it is what? Oh my God, what happened to this now? Huh. So that is why it is void, because it is impossible to perform. But because it's fraud, I have to give damages. So, what are the cases of supervening impossibility? Destruction of subject matter. You remember the theatre, We gave it to Yo-Yo before the show. The theater is burned down. Death of the promiser. When the contract is based on personal skill and confidence, the death of the promiser does not make the legal heirs liable to perform, but what happens is the contract is discharged, right? By supervening impossibility. Non-existence of a particular state of thing. You got engaged, but before the marriage, the girl turns lunatic, right? So when the girl turns lunatic, are you liable to perform the contract anymore? No. The contract is what? Void. It's not void ab initio, it's void at a later stage. Outbreak of war. Inhabitant of country one enters into a contract with inhabitant of country 2. But before we could perform the contract, there is a war. In the previous case, there was a war and we made a contract. It was void ab initio. Here, there is a contract and then there is a war. This is a void contract. And change in law, you make a contract to do some to sell some goods, but before you could sell the goods, there is a new law which makes selling of these goods impossible or illegal. The contract is discharged by change in law. Is it clear? Now here, in case of supervening impossibility, does the rule of restitution apply and can the party claim damages? Void can be used for both cautious, later also ab initio also. Okay, okay. Restitution, yes. We can get back, oh shit, huh? We can get back whatever we have paid, but damages, no. Correct? Correct? My screen is also crying. I don't know what's wrong with this. Chalo. The last one, in case of breach. What is breach? Breach means non-fulfillment of the terms of the contract, right? What is breach? Non-fulfillment of the terms of the contract. Now, breach may be actual or anticipatory. What is anticipatory is coming from the word anticipate, and when I say anticipate means I'm predicting. And when I'm predicting, it cannot be on the due date, it always has to be before. So whenever we say anticipatory, it's before or prior to the due date. What is actual? Actual is on the due date, right? What is anticipatory? It's before the due date. What is actual? It is on the due date, right? So I repeat again, what is anticipatory? It is before the due date. I can cancel the contract. Uh, I have two options on anticipatory breach. I can either cancel the contract on that very day or wait till the due date. If I cancel the contract on that very day, I can claim the damages. If I wait till the due date, now I have to wait till the due date. If on the due date the other party performs, can I say, yo, why are you performing? Take away. No, I have to accept it. But if on the other hand, the other party does not perform, this is what? This is actual breach. I can cancel and claim the damages. Is it clear to everyone? With this, we are done with this. Before we go for remedies of breach, are you clear with this? Yeah, yeah, sure, sure, sure. I'll do that. So, breach means what? Non-fulfillment of the uh, terms of the contract, right? Breach means what? Non-fulfillment of the terms of the contract. Let us say a contract is entered on the 1st and this contract is to be performed on the 20th. So 20th is the due date, right? So 20th is the due date. 20th is the due date for performance. On 9th, one party comes to know the other will not perform. This is what? anticipatory breach. This is what anticipatory breach. On this day, you have two options. You either cancel the contract or you wait till the due date. If you cancel the contract on that very day, you will get the damages. But if you wait till the due date, now you have to wait till the due date. If on the due date the other party performs, you are bound to accept it. If the other party does not perform, this is actual breach. You can cancel the contract and claim the damage. Right? You can cancel the contract and claim the damage. Correct? On the first, one party comes to know the other will not perform. He has ninth. He has two options: either cancel the contract on that very day. Oh. So when prior to the due date I come to know one party will not perform, I have two options. I can either, please ignore the spelling of cancel. Cancel the contract on that very day or wait till the due date, right? This is known as what? Anticipatory breach. If I cancel on that very day, I'll claim the damages. On the other hand, if I wait till the due date, if the other party performs on the due date, I have to accept it. If he does not perform, it is actual breach. I can cancel the contract and claim the damages. Now, what damages? Let's say on the first, the contract price was 100, right? On the first, the contract price was 100. On the 9th, the contract price goes to 120. On the 20th, the contract price goes to 150. When I cancel on 9, my damages will be this and this, that is 20 rupees. And that is if I go to the market today to buy the same goods, whatever extra I pay is my damage. On the other hand, if I cancel the contract on 20th, my damage will be 50. I hope it's clear till this point. On the 9th, I decided to keep the contract open. And in this period of time, there is a new law which says that we cannot deal in these goods anymore. So when there is a change in law, the contract is discharged by supervening impossibility. And then can I claim the damages or anything? Nothing I will get. Is it clear to everyone? Before we go to the next topic, giving you 2 minutes, go through it. If you have any doubts in it, ask me before we go forward. Yes, Sandhya. Purvi, that is, I'm just saying. Let us say, on the other hand, it could also happen, no, that on this day, instead of 150, the price goes to 110. This can also happen, no? Correct or not? Delay in due date, if you are trying to say not performing on the due date, so this is what it. Are you getting my point, Purvi? What am I trying to do? Lost it totally. Chalo, moving on to the next one. This was assumption. I said that the price goes up. The price can also go down. That can also happen, right? Okay, so what are the remedies for breach? So when we talk about remedies, broadly, we can classify the remedies under two heads. Yes, I answered you also, Kaushik. Yes. So I should appreciate you. Many people actually had to run away, see. Those who sat through, like, continuously sitting through, it's a very big thing, right? So when we say remedies, we can classify remedies under two heads: damages or monetary rights and other rights, right? So when we say damages or monetary rights, and these are what? These are the other rights. So first, let's talk about damages or monetary rights. There are four rules of damages which were laid down in the case of Hadley versus Baxendale. So, what were these four rules of damages? First, any damage which arose naturally. Any damage which arose naturally in the contract can be claimed as a matter of right. Second was special damages can be claimed only when there is a notice of the special loss. Third, remote damages can never be claimed. And fourth, any damage under a quasi contract can be. Now, when we talk about damages, we can actually classify damages under different heads. Ordinary, which arose naturally. If there is a breach, these damages will take place, right? So, the rules of damages: any damage arising in the ordinary course of the business can be claimed as a matter of right. Special damages can be claimed only if there is a notice of the special loss, right? Only special circumstances were made known. Remote damages can never be claimed, and any damage arising under a quasi contract can be claimed, right? So, damages, these were the four rules of damages. So, damages can be classified under different heads. The first one is ordinary damage. What is ordinary damage? Which arose naturally. The fact that there is a contract and the fact that the contract was breached will definitely give rise to this damage. The fact that there was a contract and the fact that this contract was breached gives me a right to claim the damages. Even if it is not mentioned in the contract, I still have a right to claim damages. Special damages are not natural damages. And since special damages are not natural, you can only claim them if there is a notice. The existence of special circumstances is not enough. Only if there is a notice, it can be claimed. Right? So, ordinary damages are natural damages and can be claimed. Special damages can be claimed only when there is a notice of the special loss. Yes, when I come to it, Asta, I'll explain. Nominal damages, nominal damages is actually no loss is suffered. So we give a damage which is as less as 1 rupee also. So when there is no damage actually suffered because of breach, we give a damage which is as less as 1 rupee. This is known as nominal damages. Vindictive or exemplary damages are basically punitive in nature, and because they are punitive in nature, they are not given in every situation. They are only given in two cases. First is breach of contract of marriage. First is breach of contract of marriage, and the second is wrongful dishonor of a customer's check. That means the customer has balance in his account, but still his check is dishonored, right? Now, penalty and liquidated damages are damages already mentioned in the contract. Now, just because I have said mentioned doesn't mean it is special damage. It is an ordinary damage only. But what we have done is we have mentioned the amount of damages that can be claimed, right? I repeat again, there are damages already mentioned in the contract. We have mentioned the amount that can be claimed as damage. It is it is not a special damage, it is ordinary only, but the amount has been mentioned in the contract. Now, it is, as I said, the amount has already been mentioned in the contract. That means what? We have written the amount that tomorrow if there is a breach, this is the damage that can be claimed. It's ordinary, but we have gone one step ahead by mentioning the amount also. Now, these damages can be either penalty or liquidated damage. Penalty means something which is very high, nowhere near to the actual damage suffered. Liquidated means the parties try to calculate or figure out the probable damage that they suffer. So if I say complete the work in 6 months, and if you take more than 6 months, I will claim from you the rent I earned and 3 times the rent I earned. So rent I earn is the actual damage I will suffer. So it's liquidated. 3 times the rent I earn is something very high. This is what? This is penalty. Whatever you mention, remember damages are never given to make profit. Right? The rule of damage is it's never given to make profit. So you will only get what you have suffered. But if you have made a contract with the government, right? In that case, if the government has mentioned a penalty, you still have to pay penalty if there is a breach. Then, rescission. If one party is ready to perform but the other refuses to accept, that is attempted performance. Instead of sitting and crying, no performance, you better go and cancel the. This is known as sue for rescission, right? This is known as what? Sue for rescission. Is it clear? Then quantum merit. Quantum means quantity, right? Quantum means quantity. Merit means merited. Whatever work is done or whatever work is merited. Let us say A had to deliver B 500 kgs of rice, but he only delivered 200 kgs, right? He only delivered how much? 200 kgs. Is B bound to accept? No, but B accepts. So when B accepts, can he refuse to pay for this 200? No. So when B accepts, he must pay for this 200. This is what quantum merit. When a contract is separable and a part has been performed. When a contract is separable and a part has been performed, payment shall be made for the part performed. Right? Payment shall be made for the part performed. Dhanush is suddenly like, he'll come back to the class suddenly. Yeah, Dhanush? Payment shall be made for the part performed. Is it clear? Right? On the other hand, if an author was asked to write a book in 6 volumes, right? An author was asked to write a book in 6 volumes. After 2 volumes, author is dead. Can we claim the price for the 2 volumes? Can the legal heir, of the author claim the price for the 2 volumes? Yes, correct, Purvi. Okay. Now, so it was a book in 6 volumes. It's not 6 different books. It is one book in 6 volumes, correct? It's not separable. So will he get the money for the two volumes? No. But if the publishers publish these two volumes, they have to pay for the two volumes, right? So if a contract is not separable and a part has been performed, no payment shall be made for the part performed. But if the other party accepts the part performed, then he has to pay for the part accepted. Correct? Specific performance basically means has to perform the contract. You have to perform, right? I'm suing you to perform the contract. This generally happens in two cases. One, when the goods have no substitute, right? When the goods have no substitute, antique goods. The goods have no substitute. So there, I don't want damages. I want the goods. So I will sue for specific performance. Or damages are not an adequate relief, right? Damages are not an adequate relief. Now, what do I mean by damages are not an adequate relief? That is, damages cannot be substituted for non-performance, right? Damages cannot be substituted for non-performance. That means this generally happens in case of immovable property. I cannot take damages because I cannot get the same goods, same place, same property, same location anywhere else. So there I want the performance and not the damages. So I'll sue for specific performance. The last one, injunction, negative act. When the contract says you cannot do this and you do that, we can stop you from doing it. You get a job, right? You get a job, and the company says that for the next 1 year, you cannot, do any practice. Or let's say you start teaching at a place, and the place where you start teaching, they say that you cannot teach anywhere else in the same city. But you go, you to moonlighting, best at moonlighting, start teaching everywhere in the city. Can we say they can sue you for injunction, stop you from doing that act? Yes or no? So this is what injunction. I hope it's clear to everyone. Now the last one, contingent contract. What is a contingent contract? It's a contract to do or not to do something on the happening or non-happening of a future uncertain event, right? What is a contingent contract? It's a contract to do or not to do something on the happening or non-happening of a future uncertain event, right? It is to do or not to do on the happening or non-happening, right? So if I see this, I get the, what you say, I get the essentials, the legal enforceability, rules of legal enforceability of a contingent contract. It can depend on the happening of an event. What happened could be? Yes, it can. A says to B, I will sell you my land if I inherit it from my father. I will sell you the land if I inherit it from my father. This contract is valid. Okay. This contract is valid. Not use this, otherwise you will say, I'm not. This contract is valid when the event happens, right? So if he inherits, event happens means what? If he inherits the land, and becomes void when the event does not happen. That is, if he does not inherit the land, right? Valid when the event happens, becomes void when the event does not happen. The next one is contingent contract dependent on the non-happening of an event. A says to B, I will give you 500 if the ship does not come to the port. As I told you, we are making another Titanic, right? You cannot hear me? You cannot hear me, guys? Am I audible? Not hear me? Yeah, it's working. Yeah, yeah. If the ship does not come to the port, I'll give you rupees 500 if the ship does not come to the port. The ship sinks. Now, when the ship sinks, that means the ship will not come to the port. So the contract becomes valid when the event does not happen. Now, you would say, but man, ship sinks, it happens. No, no. The event is if the ship does not come to the port. When the ship sinks, it does not come to the port. So it's valid. On the other hand, if the ship comes to the port, yeah, Dubuk, oh my god, Upendra remembers. Upendra remembers my Dubuk Dubuk, huh, Upendra? It's actually so nice to see that Dubuk Dubuk. On the other hand, if the ship comes to the port, the contract is what? Void. Ship comes to the port. Is it clear to everyone? Now, can it depend on third party? Absolutely, it can depend on third party. A says to B, I will give you rupees 1 lakh if I am able to marry C. Now, the contract is totally dependent on C. Yeah. Oh, that is so nice, Upendra. It's so nice to hear. I mean, remembering my examples, but remembering Dubuk Dubuk is like ultimate. That is like ultimate, Upendra. So, now tell me if C marries A, can we say contract is valid? Yeah, I forgot my example. I forgot Dubuk Dubuk. But if C marries D, can we say the contract is void? Yes. But it can happen, no, D may die and now, if it is dependent on impossible event, void ab initio, nothing to think also. A says to B, I'll give you 1 crore if I join two parallel lines. First of all, if they are parallel, they will not join, and if they join, they are not parallel. It's void ab initio. Now, what are the characteristics of a contingent contract? Obviously, for नहीं भाई हम आम है गजब आप लोग. So, what is the characteristics? What is the characteristics? First of all, can we say it is dependent on future uncertain event? Yes, I gave you so many examples of future uncertain events. Yes or no? Yes. Now, the event must be a collateral event, right? That is, it should not form a part of the reciprocal promise. That is, it should not come from the other party, right? It should not come from the other party. And finally, it cannot depend on the will of the promiser. You deliver the goods to me if I feel like I will pay. Heart paining. I don't feel like paying. No, no, I will not pay. Contingent. This is contingent. Yo, everyone will not feel like paying. Everyone will have a heart attack only when paying. Yeah. Dhanush, what was for that now? I missed it out. For what you said? Right? So event is so the it cannot depend on the will of the promise. Right? We are done. The characteristics. Did you understand contingent contract? Yes. Now the last one, quasi contract. When we say quasi contract, what is quasi contract? There is no contract between the parties, but the contract is created by law. So we have 5 types of quasi contract. The first one is goods delivered by mistake or under coercion. A has to deliver goods to B. By mistake, the goods are delivered to C. A laptop. A had to deliver goods to B. By mistake, the goods are delivered to C. Is there any contract between A and C? No. But C must either return the goods back or pay a reasonable price. Right? This is because there is a quasi contract between. This is because there is a quasi contract between. Right? Necessaries supplied to a minor or to a lunatic's family. You have supplied necessaries to, let's say, a minor or to a lunatic's family. So, is there any contract between the minor and you or the lunatic and you? No, because we cannot contract. But there is a quasi contract according to which you will be reimbursed from their property. Right? Payment made for a third party. A sold his land to B on which the government taxes are due. And obviously, if the government taxes are due, the government will seize the land. And if the government seizes the land, B's land will go. So B pays off the taxes. Who was supposed to pay? A. Who pays B? Can A recover? Yes. Is there any contract between A and B? No. But there is a, right? He can recover. Work done non-gratuitously. When I do the work for you, hoping to be paid for it. Your car was parked. A kid, he comes and starts mopping your car. You don't stop him. Are you liable to pay him or not? Obviously, you have to pay. He was not doing it free of cost, right? He was not doing it free of cost. You have to pay him. And last, finder of the goods. When a person finds goods belonging to another, there is a quasi contract between the finder and the owner that the finder will trace the owner and return the goods back to him. I know, Kaushik. Dhanush, actually, the class timings as such, we don't have any such timing. The, I mean, I'm supposed it's a marathon class, right? Correct. Now, can we say this finder of the goods will have certain rights and over the goods? Yes. This finder of the goods, what are his rights? He will have a right to claim the reward if there is any reward announced, if announced. If nothing is announced, you cannot claim. He can have a right to claim the expenses that he has incurred over the goods. He has a right to sell the goods also. When can he sell the goods? When can he sell the goods? When when can he sell the goods? When the goods are perishable or after due care the owner is not found, or the owner is found but he refuses to give the expenses that he has incurred, and these expenses are two-thirds or more of the value of the goods. So let us say the value of the goods is 1,000. He spent 100 rupees trying to search the owner, trying to take care of the goods. Can he sell the goods? No. Can he sue the owner? Yes. He spent 500 but he did not get the money. Can he sell the goods? No. Can he sue the owner? Yes. He spent 800. He asked the owner to give the money. The owner is not giving. Can he sell the goods? The lawful charges are two-thirds or more of the value of the goods. Is that clear? And last, he has the right of ownership over the goods against the whole world except the owner. Right? He has the right of ownership over the goods against the whole world except the owner. That means tomorrow if owner claims the goods, he has to give. But next, after the owner, he is the owner. No one else can take away the goods from him. I hope it's clear to everyone. What are the duties of the finder? Can we say to take care of the goods? Yes. To trace the owner? Yes. Not to mix the goods with his own goods. Correct? Done, all of you? Now, you had a doubt with this collateral transaction, right? A says to B, I will give you 1 lakh if you marry C. A says to B, I'll give you 1 lakh if I am able to marry C. In the first case, I will give you money when you marry. This is coming from the other party. When it is coming from the other party, it is reciprocal. I will give you money when I am able to marry C. In this case, the marriage is not coming from the other party. When it is not coming from the other party, it is just a collateral or a subordinate contract. It's not a part of the reciprocal promise. And then it is what? Then it is content. I hope it's clear now. Yes. I hope this point is clear now. And I now badly need to have a cup of tea before I continue. We'll do a little bit of sale of goods act also. Otherwise, tomorrow it will be too much to take. Sale, partnership, company, LLP will be too much, even though all of them equal to company contract act. But I feel, I mean, what do you guys say? Let's take a 15 minutes break. Okay? I'll see you in 15 minutes. Thank you so much, Dhanush. Thank you. Tomorrow's class timing, Varun, I really don't know right now. Yes, yes, we will continue. I will just have a cup of tea. You all also have tea, and we will meet each other in another 15 minutes. Okay? Purvi, here it's a marathon, not in this. But if it would be possible, I'll arrange another session to solve only the question answers. Okay? Okay? So I'll see you all in 15 minutes. Hello everyone, am I audible again? Yes, yes, yes. I had my tea. It was mandatory to have my tea. Okay, so now tell me, obviously we have completed the chapter, but do you still have any doubts from this chapter? If you have any doubts, we'll just, address those doubts once before we move. Did you all have tea, coffee, everything? Oh, good. So, are you ready for the next chapter? That you have doubts, you are saying? Hmm? Are you saying for the doubts? No, doubts we can still have, no? Have doubts any. So, should we start with the Sale of Goods Act? The color is so problematic here that literally it's changed the whole color of the graphics. Thank you so much, Purvi. This is motivation for us to actually keep working. So, moving on to the Sale of Goods Act. Are you ready? Guys, are you ready? Okay. So, the Sale of Goods Act 1930. Obviously, obviously, we know the meaning of 1930. What does 1930 signify? It signifies the year the act came into force. 1st of July 1930, right? 1st of July 1930. Obviously, it's a contract of sale, so it deals with the contract of, it's a contract of Sale of Goods Act. So, obviously, the chapter Sale of let us see how long we can sustain. Let us see how long we can, right? And let's see how much we can cover it. Hopefully, we'll try to cover as much as is possible. Let's see. So, Sale of Goods Act, the 1930, the act came into force on the 1st of July 1930. Since it's sale of goods, so obviously the act deals with a contract of sale. What is a contract of sale? A contract of sale is a contract whereby the seller transfers or agrees to transfer. Right? Transfers or agrees to transfer the property in the goods to the buyer for a price. So if I look at this definition, when we say contract of sale, it includes both immediate transfer of ownership or future transfer of ownership. Transfers means it is immediate ownership or it is transfer, that sale. Agrees to transfer means it's a future transfer of ownership, that means it's an agreement to sell. That means what? When I say contract of sale includes both sale and agreement to sell. What does he transfer or agree to transfer? He transfers or agrees to transfer the property in the goods. To whom does he transfer? To the buyer. And what does the transfer take place for a price? Right? What does the transfer take place for a price? Now when we say property in the, so if I look at this definition, I also get the essentials of a valid contract of sale. What is the essential? There must be two parties, buyer and seller. Transfer must be of some goods. The transfer must take place for a price. And since it is a contract, all the essentials of a valid contract must be present. Right? Since it is a contract, all the essentials of a valid contract must be present. Now, what is property? What does the phrase property in the goods mean? The phrase property in the goods means ownership of the goods. See, we are going to use this phrase so many times, right? So whenever we use this phrase, remember we are talking about ownership of the goods, right? So when we say property in the goods, what does property in the goods mean? It means we are talking about the ownership of the goods. Now, what are the essentials? The first essential is there must be two parties. And who are these two parties? Buyer and seller, right? Who are these two parties? Buyer and seller. Who is a seller? Who sells or agrees to sell, right? Who is a seller? Who sells or agrees to sell. Who is a buyer? Who buys or agrees to buy, right? Who is a seller? Who sells or agrees to sell. Who is a buyer? Who buys or agrees to buy. Now, whose ownership will be transferred? Whose ownership will be transferred? Goods, right? Whose ownership will be transferred? Goods. What is goods? Goods means movable goods. So immovable is not, no, immovable is property. So immovable will not deal, no, it's sale of goods. Here we only deal with movable goods, not with immovable goods. Immovable goods we deal with when we come to the chapter, the act immovable property, right? So here goods means any movable goods and does not include services. So when we say sale of goods, we are only talking about movable goods, not even services. Now, for what should the transfer take place? For a price. Price means what? Money. Not money's worth. Money's worth means something which can be expressed in terms of money. Now, when I say something which can be expressed in terms of money, that could be anything. That could be anything, right? When I say something that can be expressed in terms of money, that could be anything. In kind also. But here it has to be money only, not money's worth. But it can be partly in cash and partly in goods. But if it is completely in kind, then it is barter. When it is goods in exchange of goods, it's barter. When it is money in exchange of money, it's exchange. But when it is goods in exchange of money, then it is what? Then it is sale, right? Then it is what? Then it is sale. So transfer must take place for a price. Now, ownership can be transferred only for the general property and not for the special property. And if the property is subject to a special right, If the property is subject to a special right, the ownership will be transferred only when the special right is converted into general rights. How can I convert the special right into general rights? By removing of the special rights. So if the property is pledged to someone, unless the special rights of the pawnee or pledgee is removed, the ownership cannot be transferred. And since it's a contract under the Indian Contract Act, all the essentials of a valid contract, offer and acceptance, consideration, capacity to contract, free consent, lawful object, agreement not expressly declared void, two parties, intention to create legal relationship, certainty and possibility of performance, legal formalities, all of which should be present. I hope it's clear. I hope it's clear. If you have any doubts, ask me before we move forward. Just you guys, can you hear me? No doubts? Chalo. Now we will look into the all the essentials in detail. The first essential is goods. What do we mean by goods? I already told you goods means any movable goods, but does not include money or actionable claims, right? So anything goods means anything which is movable, but money or actionable claims is not considered as goods. Money you obviously know, no problem. Money you obviously know. Actionable claims means when someone owes you money, that person has a right to file a case against you, right? So that is known as actionable claims. Any unsecured debts which can be enforced in the court of law. Now, anything which is a part of land or attached to land, is it goods? Anything which is attached to land, is it goods? Yes, they are considered as goods provided we sever them from the land at the time of sale. That is, at the time of selling them, I don't sell them with the land, I detach them from the land and sell them. If I detach them from the land and sell them, then it is goods, otherwise it is not goods, right? Yes, definitely, Kaushik, thank you. Now, goods can be classified into three heads: existing, future, and contingent. The name itself tells me goods. What is existing? I have them when I contract to sell them. So, when I contract to sell these goods, I have these goods. Future, I don't have these goods. When I contract to sell these goods, I don't have these goods. But after the contract is made, if I'm a manufacturer, I'll manufacture them. If I'm a producer, I'll produce them. If I have to procure it from someone, I'll procure and sell them. Contingent, I don't have these goods. I don't know I'll get the goods or not. If I get the goods, I'll sell. Otherwise, I'll not. So, existing goods, goods which are in the possession, goods which are in the possession of the seller at the time of contract, right? Goods which are in the possession of the seller at the time of contract. Future, goods which are not in the possession of the seller but will be procured or produced or manufactured by him after the contract is made. Contingent, goods the acquisition of which by the seller depends upon a contingency, that is an event which may or may not happen. Right? That is an event which may or may not happen. Is it clear? I say I will sell this pen to you, existing. I will sell the pen to you which I get from him, future. If I am able to get the pen from him, I'll sell it to you, contingent. Yeah? Now, existing goods can again be classified into specific, ascertain and unascertain. I'll just give you a very easy way to understand all the three words. Remember, ascertain never exists on its own. Okay? Ascertain goods never exist on its own. Also, ascertain goods never exist on its own. It is always unascertain goods which are ascertain. Right? It is always unascertain goods which are ascertain. Specific is identified. Unascertained is described. When as per the description the goods are set out, they are ascertain. Right? I repeat again, specific is identified. Did I even tell you this pen example? I don't remember, Kaushal. Specific is identified, ascertained is described. When as per the description the goods are set out, they are ascertained. Okay? I want this pen, specific. I repeat again, I want this pen, specific. I want a surface, metal body, red color pen. Describe. Ma'am, you gave the brand of the goods. Branding is description. Right? Branding is description. I want this pen. Identify. I want a surface, metal body, red color pen. Unascertained. When as per the description, the shopkeeper takes out the pen, he is ascertained. So, when I identify that this is the goods I want, it is what? Specific. When I describe, branding is description, it is unascertained. When as per the description, the goods are set out, the goods are ascertained. Is it clear? Is it clear? Now, one thing remember, if future goods and I don't get the goods, I can claim damages. If contingent goods and I don't get the goods, I cannot claim damages. Is it? I don't even remember, guys. Now, how do we fix the price in a contract of sale? How do we fix the price? Subsequent means after. How do we fix the price in a contract of sale? Now, in a contract of sale, price can be fixed in three ways. Okay. In a contract of sale, price can be fixed in three ways. So, what are the three ways of fixing of price? It can be fixed by agreement, right? It can be fixed. Wow, it is like literally the color does not even show. Let's try a different color. Which one? Green? Ayo, ayo, yo, yo, nothing is left of this. By mutual dealings or by third parties, right? What is by agreement? The parties mutually fix the price of the goods in the agreement. That is, mutually when they make the agreement, they fix the price of the goods. I'll sell at this price, he agrees. I'll buy at this price, he agrees, right? What is by mutual dealings? What is by mutual dealings? We deal with each other on a regular basis, and because of our regular dealings, we have terms using which we can fix the price of the goods. We deal with each other on a regular basis, and because of our regular dealings, we have terms using which we can fix the price of the goods. So, price is fixed by mutual dealings, right? Like I always sell you the goods at 10% below market price, right? Or I always sell you the goods at whatever is the average pricing, whatever. Some means are there. So I will fix the price as per those means. And it can be fixed by third parties. Ma'am, third party bole to obviously we are talking about valuers, right? Otherwise, third party is not a piece mark ki aake fix karega. We are basically talking about valuers. Now, if the valuer refuses to fix, this is a contingent contract. And if the valuer refuses to fix the price of the goods, the contract is void. If the valuer refuses to fix the price of the goods, the contract is void. Ma'am, but I want to sell, he wants to buy. So make a new contract, no problem. This contract is void. Okay? If a part of the contract is performed, if a part of the contract is performed and the valuer refuses to fix the price of the goods, then for the part which has been performed, it's valid. What is trying? This color is actually good. For the part which has been performed, it's valid, but for the part which has not been performed, it is what? It is void. The part which has not been performed, it is what? It is void. Now, the next one, delivery. First unit is basically all the small topics. We'll kind of see the shunting between the topics, right? So, delivery. When we say delivery, what do we mean by delivery? Delivery means the voluntary. It is not a statutory or a forced or choice. It's a voluntary. It's not a statutory transfer. It's not just transfer. It's not a forced transfer. It's a voluntary. That means the seller, by his choice, transfers the possession of the goods to the buyer, right? The seller, by his choice, transfers the possession of the goods to the buyer. Now, there are three types of delivery. Before I studied this, I thought there is one delivery, I give you the goods, that's delivery. But actually, there are three types of delivery. So, what are the three types of delivery? Actual, symbolic, and constructive, right? Actual, symbolic, and constructive. I give you this pen. I give you this pen. And I tell you, I sold this pen to you and I give you this pen. This is what? Actual delivery. Okay? Physical possession of the goods are transferred. I give you this pen. I sold this pen to you and I hand over this pen to you. Actual delivery. This pen is kept in my godown. I give you the keys of the godown and I tell you, please go and take the delivery. Symbolic. I don't give you the goods here, but I give you certain means using which you can take the possession of the goods. I don't give you the goods, but I give you certain means like keys or the document of title using which you can take the delivery of the goods. I did not understand, Sandhya. What was this question? Oh, Varun, how can I forget that? You give me Varun, you tell me, how can I ever forget that? She's not there. Rishabh was asking me 2 days back only when is the revision, but he has attended the class. I don't know why. Rishika is also not there. But Rishika, please do remind Rishika that we are remembering her necessity. Then, so what is the symbol? It could be you know, the keys or the document of title. I still did not understand. What is it in transit? Transit ho gaya, delivery done. Already done. Constructive. I have kept this pen in someone else's godown. I tell you, please take the pen. You say, let it be there. Anyway, I have to keep it somewhere. So I say to the third party that, see, the pen has been sold to you, and now you are holding the pen not for me but for that person. The moment I acknowledge this, the delivery takes place, right? So, delivery without which, this will be without, not which. Delivery without any change, delivery without any change in the custody or actual possession. This is also known as delivery by acknowledgement or atonement, right? Oh, Rishabh, it's you. आज आपका नाम अलग है तो ऋषभ I couldn't identify. The same Rishabh, Shishadripuram. चलो. We are done with this. Before I move to the second unit, Acha, one thing I wanted to talk about, destruction of subject matter. Destruction of subject matter. What happens to the contract if the goods are destroyed? What happens to the contract if the goods are destroyed before agreement or after agreement before sale? Now, if the goods are destroyed before agreement, it is void ab initio. Right? If the goods are destroyed before agreement, it is void ab initio. The contract is what? Void ab initio. Irrespective of whatever types of goods. The goods are only not there. It is, can we say, bilateral mistake? Yes or no? We can call it as a bilateral mistake. Correct? After agreement before sale, depending on whether the goods are specific goods or unascertained goods. If specific goods are destroyed, the contract is void. I want this pen and this pen is gone. No other pen can be this pen. So the contract is void. But if it is unascertained goods, the contract is valid. I told you I want a pen, a surface pen. For me, every surface pen is equal. Right? Every surface pen is equal. So even if one is lost, I can get another one. So the contract remains valid. Is it clear? Is it clear? Can I now move to the next part? Well, Upendra said, so we'll just talk about it. Yes, this is supervening impossibility. This is existing at the time of contract. Remember we did in discharge of the contract existing at the time of contract. Now, the next unit basically talks about conditions and warranties. So what do I mean by conditions and what do I mean by warranties? Both conditions and warranties are stipulations. So conditions are stipulations which are essential for the main purpose of the contract. Essential for the main purpose. Now they are essential. So if there is a breach of these conditions, I can cancel the contract and claim the damage. Right? I repeat again, conditions are stipulations which are essential for the main purpose of the contract and a breach of which gives the party a right to cancel the contract and claim the damages. Whereas when we say warranties, warranties run collateral to the main contract. Right? And if there is a breach of warranty, you cannot cancel the contract, you can only claim the damages. If there is a breach of warranty, you cannot cancel the contract, you can only claim the damages. Now, both of these conditions and warranties can be express or implied. What is expressed depends on whatever the parties agree. Now, what the seller and buyer will agree, how can I say that? It could be anything and everything under the sun. I cannot pinpoint this is it, this is it. No, it could be anything. Right? It could be just anything. So when we say express, I cannot tell you this is express. It could be just about anything. But when we say implied, implied means what? It is by law. That is, law says when the seller sells the goods to the buyer, these conditions and warranties have to be fulfilled. right? Law says when the seller sells the goods to the buyer, these conditions and warranties have to be fulfilled. And if these conditions or warranties are not fulfilled, then I can cancel the contract and claim the damages or claim the damages as the case. Now, when we say conditions, okay, when we say conditions, there are eight implied conditions. The first one is title. Now, what do we mean by title? Title means the ownership of the goods. Now, when I buy goods, I never ask the seller, "Arey, oh seller bhaiya, is it your goods or chori ka goods?" No. I imply that since he is selling the goods to me, he has a right to sell the goods, right? Or if he agrees to sell the goods on a future date, on that future date, he will have the rights to sell. Now, if the seller has no rights to sell, and the buyer is deprived of the goods by the true owner, the buyer can claim the price from the seller, right? Why have you all gone silent? Absolutely. Are you understanding or too exhausted? Huh? Why are you so silent? Not understanding or too exhausted to understand? Understanding, no? So when the seller sells the goods to the buyer will never ask him, "Oh seller bhaiya, your goods or someone else's goods." The fact that he is selling means he has the right to sell. And if the seller has no rights to sell and the buyer is deprived of the goods by the true owner, the buyer can claim the price from the seller. Correct? The next one, sale by sample. What is sale by sample? I show you the sample. If you like, you can purchase. The goods, three conditions have to be fulfilled. First, the bulk of the goods that I receive must be just as per the sample. Second, the buyer must be given an opportunity to examine the goods. So I'm not going to blind fatedly trust the seller and keep the goods. I'm going to check the goods before I buy them. And the goods must not have any hidden defect. The goods must not have any hidden defect which cannot be found on examination but makes the goods unmerchantable. That is, there should not be any hidden defect making the goods unmerchantable. If any one of the condition is not fulfilled, the buyer can return the goods back. Right? So, the bulk must correspond to the sample. The buyer must be given an opportunity to examine the goods, and the goods must not have any latent defect which makes them unmerchantable. If all these three conditions are not fulfilled, the buyer can cancel the contract or and claim the damages. The next one, sale by description. What is sale by description? I describe the goods to you. If you like it, you can purchase. Right? I describe the goods to you. If you like it, you can purchase. When the sale is made by description, the bulk of the goods must correspond to the description. When the sale is made by description, the bulk of the goods must correspond to the description. Can I give a description of packing? Yes. So if the seller describes the packing, that this is how I am going to pack the goods, then in that case, that also becomes a part of condition as to description. And if the goods are not packed as per the description, the buyer can cancel the contract. So description of packing is also a part of condition as to description. I hope it's clear to everyone. The next one, sale by sample as well as description. When the sale is made by sample as well as description, the sample must be described as it is known in the market. Means the whatever sample you are showing me, you must describe it as per the generic name or as per the name that is used in the market, not generic as per the specified name of the product. And the bulk of the goods must correspond to both sample and description. So sample must be described as it is known in the market and the bulk must correspond to both sample and description. If both the conditions are not fulfilled, I can cancel the contract and claim the damage. Am I going fast? Now the next one, condition as to specific purpose of the buyer. And now when the buyer specifies the reason of his purchase, that is he tells the seller the reason he is purchasing the goods, depends upon the seller's skill and judgment. That is, he lets the seller select the goods for him. He does not interfere with the selection. He lets the seller select the goods for him. Right? And the seller deals in those goods. Why is it important that he should deal in those goods? When I go to a mobile dealer, he knows the ins and outs of a mobile. But when I go to a cloth dealer, he will know the ins and outs of cloth, not mobile. The specific dealer knows the ins and outs of the goods. So if he is a dealer of those goods, he will be in a right place to identify the goods that I need. If these conditions are not fulfilled, I can return the goods back and claim the price. Usage of trade. So when I purchase an umbrella, do I need to say, give me an umbrella which protects me from the rain? Huh? Do I need to say, give me an umbrella which protects me from the rain? It's an umbrella. It's supposed to protect you from the rain. If it does not, can you return the goods back? Yes, you can return the goods back. Merchantability means the goods should be in a saleable or a usable state. Oh yes, how can I forget, Ramki? I remember. So what is merchantability? The goods must be, yes, Siddharth, absolutely. Oh my God. Ramke will have hiccups, Everyone is remembering him. So when we say merchantability, goods should be in a saleable. What is merchantability? Merchantability means the goods should be in a saleable or a usable state. If the packing of the goods is defective, okay, that also makes the goods unmerchantable. So you purchase a packet of chips and there is no vacuum in it. You purchase a packet of biscuit, all the biscuits are crumbled, right? Right? You purchase a box of cornflakes and when you shake it, all you hear is not the corn flakes, but rather the crushed flakes. So can we say all in all of these cases, huh? Today only one person, Nikita. Ramke is not here, no, otherwise I would have drawn both the persons, right? So can we say this also makes the goods unmerchantable? Yes. So if the packing of the goods is defective, that also makes the goods unmerchantable. Now, if a person has any personal ailment, like I'm allergic to a particular good, right? I'm allergic to a particular good, so that does not make the goods unmerchantable. So, personal ailment of a person, now this is gone. The personal ailment of a person does not make the goods unmerchantable, right? Wholesomeness is an extension of merchantability. Okay, wholesomeness is an extension of merchantability. In case of eatables, consumable goods, okay, in case of consumable goods, that is eatables, food provisions, apart from being merchantable, they should be wholesome. That is, they should be in a consumable state. That is, they should be in a state where we can consume them. If they are not in a consumable state, can I return the goods back? Yes. Like stone in a bun or decomposed snake in a beer, bottle of beer, or worms in Cadbury, not in a consumable state. Now the next one, warranty. Just like implied conditions, we also have some implied warranties. Implied warranties are warranties which are given by law. Law says that when the seller sells the goods to the buyer, these warranties have to be fulfilled. And if these warranties are not fulfilled, the buyer can cancel the contract and claim the damages as the case. Right? Now the first one, yes, the milk wala example, the typhoid germs in the milk packet. Undisturbed or quiet possession. So basically this undisturbed or quiet possession is nothing but condition as to title. If there is a breach of condition as to title, you must have claimed the whole price. But instead of claiming the whole price, you only claim the damages. So you have treated a breach of condition as a breach of warranty. So this undisturbed or quiet possession is nothing but breach of condition as to title, which is treated as a warranty. Correct? Freedom from encumbrances. The next warranty is non-existence or freedom from encumbrances. Whenever a property is whenever a property is subject to the special rights of a third party, the property is charged. And because of this third party's right, if the seller sells the goods without removing the third party's rights, the buyer may suffer losses. And these losses or damages can be claimed by the buyer from the seller. So when the seller sells goods to the buyer on which a third party has a charge, and owing to this charge, the buyer suffers any damage, the buyer can claim these damages from the seller. Correct? Exactly. Gabbar and the piano example. Not Thakur, Thakur, Thakur. Thakur and Gabbar example. Thakur, Thakur. The next one, disclosure of dangerous nature of the goods. Disclosure of dangerous nature of the goods. When the goods are of a dangerous nature, right? When the goods are of a dangerous nature, it is the duty of the seller to inform the buyer about the dangerous nature of the goods. How can he do this? He can do it by personally telling it, or he can do it by putting it up on the package. If the seller fails to inform the buyer about the dangerous nature of the goods and because of this the buyer suffers any damage, the buyer can claim these damages from the seller. So I repeat again, whenever the goods are of a dangerous nature, it is the duty of the seller to inform the buyer about the dangerous nature of the goods. If he fails to do so and the buyer suffers any damage, the buyer can claim these damages from the seller. Correct? And the last one, this is again that umbrella thing. Instead of returning the umbrella, you claim only the damages. Again, you have treated a breach of condition as breach of warranty. Right? You have treated a breach of condition as a breach of warranty. Yes, Starbucks coffee, that was dangerous nature of the goods. Correct. Caveat emptor, last topic of this unit. What is caveat emptor? Let the buyer be. Right? What is caveat emptor? Let the buyer beware. The name of the case was Ward versus Hobbs, and 32 pigs were sold in an auction inclusive of all defects. The buyer examined the pigs, liked them, purchased. When he bought the pigs home, he realized that these pigs were suffering from swine fever. These pigs तो gone. घूमने को नहीं, gone. His pigs were also dead. He wants to claim the price and damages. The reason he will not get anything was, first, it was an auction sale. And in auction sales, the seller is not required to tell anything. The goods are there. You see, you like, you purchase. Second, the buyer had examined the goods. And third, it was written the pigs were sold, the goods were sold inclusive of all defects. The buyer will have no remedy. Yes, Upendra, absolutely. So caveat emptor, let the buyer beware. What it means is the buyer is responsible for the wrong selection of the goods made by him. The seller is not responsible, right? Caveat emptor, let the buyer beware. However, law में क्या होता है? लोचा. However, law में क्या होता है? लोचा. So there are cases where the rule of caveat emptor does not apply. So what are the cases where the rule of caveat emptor does not apply? And we will just sum it up in one line. First, in all the implied conditions, okay? In all the implied conditions, the rule of caveat emptor does not apply. Second, if the goods are purchased under a trade name, right? If the goods are purchased under a trade name or a brand name, the condition. Is it clear to everyone? Did you understand whatever we have done so far? Any doubts you have? Before we continue, let me just get water for myself. There's no water. You all also have water. Okay, so minutes to done, but this was quite a little quick also. No doubts, no, I hope. We should continue or continue tomorrow. What should we do? Should we continue or continue tomorrow? One says the other will. Everyone is saying continue. We'll just chapter. I mean, your Josh deserves an applaud. Everyone, your Josh deserves an applause. So, moving on to the next unit. This unit basically talks about transfer of property and everything relating to transfer of property. So, Upendra gone, no option. So, transfer of property. When we say transfer of property, there are three stages in which by then the act will only get over. Property. There are three stages in which the property is transferred: property in the goods, possession of the goods, and passing of risk. Right. So, property in the goods. Property in the goods means the ownership of the goods. Possession of the goods means the physical goods. Passing of risk. Now, risk is something which is associated with the physical goods. Risk will happen to the goods. Loss will happen to the goods. So when I say risk, risk is something which is associated with the physical goods. So risk passes with ownership whether delivery is made or not. Irrespective of whoever, right? Irrespective of whoever has the possession of the goods, risk passes with ownership. So risk passes with ownership whether delivery is made or not. Till the time Till the time the seller is the owner, risk is with the seller. But once the ownership is transferred to the buyer, risk also passes on to the buyer. However, the parties may agree differently to bear the risk. One very important thing here is if any party is at fault, the defaulting party shall bear the risk. If any party is at fault, in that case, the defaulting party will. Correct? Now, now, when we say time, now why is it important to know who is the owner of the goods? Right? Why is it important to know who is the owner of the goods? The reason being the jus in rem belongs to the owner. The reason being the loss of goods belong to the owner. The reason being that if loss happens due to a third party, the right to sue the third party also lies with the owner. That is why it is important to know who is the owner of the, right? That is why it is important to know who is the owner. So when does the ownership transfer from the seller to the buyer? In the contract, we may specify. In the contract, we may specify that the ownership will be transferred on, this period, this time. It could be when delivery is made, when payment is made, on this specific day, after these many days, anything. So when it is mentioned, when it is mentioned that the ownership will be transferred after these many days or on the happening of this event, the ownership will be transferred as per whatever is agreed. But if nothing is mentioned, then depending on the type of goods, whether it is specific goods or unascertained goods, ownership is transferred. In case of specific goods, when is the ownership transferred? In case of specific goods, first, if the goods are in a deliverable state. What is deliverable state? Buyer is bound to take the delivery. It is not the buyer can take the delivery or the seller can give the delivery. No, buyer is bound to take the delivery of the goods. If the goods are in a deliverable state, the ownership is transferred immediately. Right? If the goods are in a deliverable state, the ownership is transferred immediately. Now, if the goods are not in a deliverable state, ownership will be transferred after they are bought to a deliverable state and buyer is informed. Right? Obviously, you bought it to the deliverable state. Unless I come to know, there is no transfer of ownership. So, when I am in. Now, if the seller has to conduct tests over the goods, why would he conduct tests over the goods? Maybe he wants to know the price, quantity, quality, identity, any reason whatsoever. If the seller has to conduct tests over the goods, we wait. See, it's his goods he's selling us. So we wait for him to conduct the test and the ownership is transferred after such test. But if the buyer has to conduct the test, the ownership is transferred immediately. Why so? If the buyer wants to conduct the test, he could have said that, see, I am ready to purchase, but I want to conduct the test. He did not say, he simply accepted the goods. When he simply accepted the goods, it's valid. Now you have nothing else to do, right? So I repeat again, if I have to conduct the test, the ownership is transferred immediately. Is it clear? So I repeat again, if specific goods in a deliverable state, ownership is transferred immediately. Not in a deliverable state, ownership is transferred after the goods are bought to a deliverable state and the buyer is informed. If the seller has to conduct tests over the goods, ownership is transferred immediately. The buyer has to conduct the, I'm so sorry, seller has to conduct the test, the ownership is transferred after the tests are conducted. The buyer has to conduct the test, the ownership is transferred immediately. In case of unascertained goods, ownership is transferred after the goods are ascertained and appropriate. Right? What is this ascertained and appropriate? I go to the seller and I tell him I want a surface red color metal body pen. Unascertained. As per my description, the seller will take out the goods. When he takes out the goods, he has ascertained. Now he will come and confirm it with me. Ma'am, is this the pen you want? I'll see, yeah, yeah. This is the pen I want. This is what? Appropriate. No. Ownership is transferred after the goods are ascertained and appropriated. What is ascertaining? Goods answering the description are identified and set apart. What is appropriation? Selection of the goods with the consent of both the parties for the performance of the contract. Is it clear to everyone? Yes. Now, sale on approval. What is sale on approval? I give you the goods. If you like, you can purchase. If you don't like, you may not purchase. You can return the goods back to me. Sale on approval becomes a sale when either the buyer gives his consent or if some time is specified, within that time the buyer does not return the goods back, rather keeps the goods with himself, or if no time is specified, up to a reasonable time he does not return the goods back, right? He does not return the goods back or he, so I just lost it. Started looking at the message. I'm so sorry. If no time is given within a reasonable time, he does not return the goods back or he retains the goods beyond the reasonable time. It automatically becomes a sale, right? So if no time is given within a reasonable time, I should either return the goods back or at least I should inform the seller I don't want to keep the goods. And third, he does any act which an owner can do. That means he does anything with the goods which an owner can do. So the fact that he does anything with the goods which an owner can do, it automatically means a sale. Is it clear? Mohan, since I am actually discussing Sale of Goods Act right now, I don't want to go into Companies Act. Tomorrow, when we do Companies Act, that topic is there. You please ask me. So, you ask me at the end, it's still okay. So, buyer gives his. So, buyer gives his consent, or he does not give his consent but retains the goods within the specified time, after the specified time or reasonable time, or does any act which an owner can do, that is, which is consistent with ownership. On the other hand, if it is sale on approval on cash basis, okay, if it is sale on approval on cash basis, ownership is transferred after the cash is paid, right? What you want to see, Nikita, this? This one only, no, Nikita? I'm sure that's if I'm not the owner of the goods, can I transfer the ownership to someone else? If I am not the owner of the goods, can I transfer the ownership to someone else? No. To transfer the ownership of the goods, I must first have the ownership of the goods. Nemo dat quod non habet. No one can give what he has not got. If I don't have the ownership of the goods, how can I sell it to someone else? लेकिन लॉ में क्या होता है? There are cases where a non-owner can sell the goods and it's absolutely sale by a mercantile agent. First of all, what are the rights of a mercantile agent? He can buy the goods, he can sell the goods, he can consign the goods for sale, or he can even pledge the goods, right? What are the rights of a mercantile agent? He can sell the goods, he can buy the goods, he can consign the goods for sale, he can even pledge the goods. Now, when a mercantile agent when a mercantile agent acting in the ordinary course of the business, that is, it is his usual work. He is not acting as a mercantile agent only for this contract, but it is his usual work. Has the possession of the goods with the consent of the owner. How did he get the possession of the goods? With the owner's consent. He got the possession of the goods with the owner's consent. And he sells this to a he sells these goods to a bona fide purchaser. Bona fide means who buys in good faith. If all these three conditions are fulfilled, the sale is a valid, right? So when a mercantile agent acting in the ordinary course of the business has the possession of the goods with the consent of the owner, sells it to a bona fide purchaser, the sale is valid. Sale by one of the joint owners. What is joint owners? When a property is owned by more than one person, we call them joint owners. Now, if one of the joint owners has the possession of the goods with the consent of the other joint owners, right? If one of the joint owners has the possession of the goods with the consent of other joint owners and sells them to a bona fide purchaser, the sale is valid. So, one of the joint owners has the one of the joint owners has the possession of the goods with the consent of the other joint owners and he sells it to a bona fide purchaser, right? Sells it to a bona fide purchaser. The sale is what? Sale is valid. Now the next one, sale by a person in possession under a voidable contract. Sale by a person in possession under a voidable contract. Where a person has, now please understand it is under a voidable contract. So if a person has the possession of the goods under a voidable contract and before the contract, this is very important, right? This is very important before the contract is cancelled because the possession has to be under a voidable contract. And before the contract is cancelled, sells it to a bona fide purchaser, right? Sells it to a bona fide purchaser. The sale is what? Valid. The sale is what? Valid. The next one, sale by estoppel. Sale by estoppel. What is estoppel? Stopped from denying. When the owner of the goods lets the buyer believe that the person who is selling him the goods has a right to sell. Let's say O is the owner, but in O's presence, S is selling the goods to B. O should have stopped. No, Are bhai, why are you selling? But O does not stop him. So when O does not stop him, can we say he makes B believe that S has a right to sell? Yes. The sale is what? The sale is valid. Right? The sale is valid. Now, sale by a person in possession after sale. S sold his goods to B, but the goods are still with S. He resells them to P. The sale is valid. S sold his goods to B, but the goods are still but the goods are still with S, and he resells them to P. The sale is what? The sale is valid. Sale by a person in possession before sale. I gave you the possession of the goods, not the ownership. I will transfer the ownership on a future date. And before I transfer the ownership to you, you sell it to another person. The sale is valid. Sale by an unpaid seller. This we will do in the next unit, so I'm not going into this. Until point number 7, till this point, whatever we did, it was under the Sale of Goods Act. Now the last, there are other acts also which makes sale by non-owners valid. For example, sale by finder of the goods under the Contract Act. Similarly, sale by pawnee or pledgee under the Contract Act, there the non-owners sell the goods and the sale is absolutely valid. Or in case a person becomes insolvent, sale by the official assignees. They are not the owners of the goods, but still they sell the goods and the sale is what? The sale is valid. Correct? I hope all the lochas are clear. Any doubts you have? Now, the appropriation of the goods. Now, the appropriation of the goods must be what? The appropriation of the goods must be unconditional. Right? The appropriation of the goods must be what? The appropriation of the goods must be unconditional. It is unconditional when the seller does not reserve the rights of disposal. It is unconditional when the seller does not reserve the rights of disposal. When the seller reserves the rights of disposal, the appropriation is conditional. What is reserve the rights of disposal? When we say disposal, disposal can be transfer of ownership or transfer of possession. When the seller keeps in his control, the ultimate disposal of the goods. Disposal can be transfer of ownership or transfer of possession. When the seller keeps in his control the ultimate disposal of the goods to the buyer, he has reserved the rights of disposal. When the seller keeps in his control the ultimate disposal of the goods to the buyer, he has reserved the rights of disposal. Making a conditional transfer of ownership or making a conditional transfer of possession. That's reservation of rights to dispose. Appropriation must always be unconditional. So sending a document of title along with bill of exchange means if you accept the bill of exchange only then you become the owner of the goods, otherwise not. This is reservation of rights to dispose. Clear all of you? Clear all of you? Okay. I don't know about you guys. I thought I'll continue. I'm super exhausted. Let's continue. Is that okay with Though I had thought I will complete this unit, but now I'm like, I'm done. I'll continue tomorrow. I'll start tomorrow's class a little earlier. I'll ask them earlier today. Anyway, it would have almost 7 hours since we have been doing this class. Exactly. Brains are buffering. I totally understand and it's so relatable. Anyway, hats off to you guys for sitting through for 7 hours. That, like, you people rock. You people are like great. So I will see you all tomorrow. Probably the class will be a little earlier. Today, 1 hour was delayed because of that also, of the camera and stuff. So 10:30. 10:30 is good, no, Varun? By the time we start and everything, 10:30. 10:30 or 11, same time. 30 or 11 only I'll keep it. Okay. So thank you guys, and please revise whatever we have done. However much you can revise, please revise whatever we have done. Please at least make the full utilization of whatever we have done, so that you get the full, outcome also of this. Bye bye. Good night. Yes. So thank you. Yes. Bye bye bye. So I will see you all tomorrow. Okay. I'll see you all tomorrow. Yes, I'll take rest. Yeah, sure, Varun. I need to do a little bit of update. I'll do that, and after tomorrow, I'll share it. Like, it's some topics I need to add and stuff. So I'll do it tomorrow, and then day after tomorrow. Okay. Good night. Bye bye. Take care. And I end the streaming here. Take care. Yeah, I'll send it, but not today. A few changes needs to be done here and there. I'll do it tomorrow. Today I won't do. Tomorrow I'll do, and then I'll send it. Okay. Bye, 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 bye. Bye, guys. Bye, guys. Bye, guys.